Hey, we're going to start. You say Pete, bye-bye. All right, we're going to go on the record, 2022 CR 9260, State of Texas versus Richard Anthony Montez. Can I have parties announced for the record for the state?
Andy Shimoda and John Kingston.
For the defense?
Orlando Castellano and Kelly Fiddle.
All right, and the court will note that the defendant is in the courtroom and the jury has not been brought in. My understanding, there's an objection to the charge, state?
Well, Judge, there is surplusage in the charge with regard to the statute of limitations and whether or not it told. In essence, the charge as it sits right now presents the jury evidence that they have not heard anything about. There have been no hearings prior to trial, during trial, or at any point thereafter that would merit the tolling language or the statute of limitations language or anything like that. The state feels that it's just merely confusing. It's not in dispute between the two parties. The defense has never brought up any conditions with regard to this, no issues with it whatsoever. So we feel like the extra language that is in this charge would only serve to confuse the jury over a matter that they really have no evidence about. They had heard nothing about this. This will be the first time they're hearing it when the jury charge is read. Because the defense never presented any objections to it, because it is not in dispute, we're requesting that surplusage be removed.
All right, defense, are you disputing the statute of limitations
Yes, Judge.
based upon?
Well, it's more in relation to the lesser included that they're asking for, Judge.
Well, I mean, the lesser included has been admitted, so the court's main question is, are you saying that that there's some issue related to the statute of limitations with regards to the lesser included? And if so, what is that being based upon?
Well, Judge, in regards to the statute of limitations and states that we've never made any objections to it, it was not brought up until the charging conference that they were going to be asking for a lesser included. At that time, we made the timely objection against the lesser included, which goes towards the statute of limitations as to it being outside, the lesser included being outside of the statute of limitations. And so that's why we're objecting.
That was never part of their argument, Judge, with regard to not wanting the aggravated assault lesser.
Okay. All right, the court would deny the state's request. Is there anything else from either side?
Only one issue, Judge. My screen is not functioning properly. Okay.
Or like if your dongle connection,
Uh-huh.
being it's an Apple device, a lot of times our Apple devices like that, with that dongle connection, it tends not to send the signal properly to our equipment.
And so is there a solution?
One other thing is to put whatever you got on a USB or something from the
I have it on
Yeah,
USB.
or this on your face and another device over on PC, on their PC. Just so that you know.
I have it ready to go on a USB.
All right, so can you show them how to do that with the USB? All right. Yes, we're ready.
All rise for the jury.
All right, everyone, please be seated. Good morning. I can see everybody was able to find parking today. That's always a good thing. All right, so yesterday, both the state and the defense rested. State, do you close?
Stay close.
That's fine.
All right, ladies and gentlemen, I'm going to read to you what's called the charge of the court. It's the jury charge. You don't have to worry about memorizing it because you'll be given a copy in the back, okay? Charge of the court. Members of the jury. The defendant, Richard MONTEZ, stands charged in count 1 of the indictment with the offense of capital murder alleged to have been committed on or about the 3rd day of February 2018 in Bexar County, Texas. The defendant, Richard MONTEZ, stands charged in counts 2 and 3 of the indictment with the offense of murder alleged to have been committed on or about the 3rd day of February 2018 in Bexar County, Texas. To all of these offenses, the defendant has pleaded not guilty. One, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual or intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual or commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. Two, the offense of aggravated assault is a felony offense. Our law provides that a person commits the offense of aggravated assault if the person commits an assault by intentionally or knowingly causing bodily injury to another and uses or exhibits a deadly weapon during the commission of such assault, or if the person intentionally or knowingly causes serious bodily injury to another. 3, our law provides that a person commits the offense of capital murder when such person intentionally or knowingly causes the death of more than one individual during the same criminal transaction or during different criminal transactions but pursuant to the same scheme or course of conduct. 4, individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Act means a bodily movement, whether voluntary or involuntarily. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. 5, A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6, you are instructed that an accomplice witness, as the term is hereinafter used, means any person connected with the crime charged as a party thereto, and includes all persons who are connected with the crime as such parties by unlawful act or omission on their part, transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the crime. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness unless the jury first believes that the accomplice witness's testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict unless the accomplice witness's testimony is corroborated by other evidence tending to connect the defendant with the offense charged, and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with its commission. The witness, Juan Martinez, is an accomplice. If an offense was committed and you cannot convict the defendant upon his testimony, unless you first believe that the portion of his testimony that ascribes guilt to the defendant is true and shows that the defendant is guilty as charged, and then you cannot convict the defendant upon said testimony unless you further believe that there is other evidence in the case outside of the evidence of the said accomplice tending to connect the defendant with the offense committed. If you find that an offense was committed and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with this commission, and then from all of the evidence, you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. 7, our law provides a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with the commission of the offense. Mere presence alone will not make a person a party to an offense. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. 8, self-defense. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. A person has a right to defend from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. When a person believes, as viewed from his standpoint, that he is in danger of an unlawful attack or a threatened attack at the hands of more than one assailant, he has a right to defend himself as instructed herein against either or both of them. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause or in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, And 3, who is not engaged in criminal activity at the time of the deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant's conduct was not justified by self-defense. Now, keeping in mind these instructions, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant committed the charge and instructed offense, you must next decide whether the state has proven beyond a reasonable doubt that the conduct was not justified by self-defense. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant committed the charge and instructed offense, but if you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Richard MONTEZ reasonably believed, as viewed from his standpoint, that Margarito Vigil and or Benito Gallegos were using or attempting to use unlawful deadly force against him. And 2, Richard MONTEZ reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Margarito Vigil's and or Benito Gallegos' use or attempted use of unlawful deadly force. And 3, Richard MONTEZ's use of deadly force was not in response to verbal provocation alone, then you will acquit the defendant and say by your verdict, not guilty. But if you find from the evidence beyond a reasonable doubt that the defendant committed the charged and instructed offense, and you further find from the evidence beyond a reasonable doubt that 1, Richard MONTEZ did not reasonably believe, as viewed from his standpoint, that Margarito Vigil and Benito Gallegos were using or attempted to use unlawful deadly force against him, or 2, Richard MONTEZ did not reasonably believe, as viewed from his standpoint, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Margarito Vigil's and Benito Gallegos' use or attempted use of unlawful deadly force, or 3, Richard MONTEZ's use of deadly force was in response to verbal provocation alone, then you will find the defendant on his plea. Then you will find against the defendant on his plea of self-defense. 9, you are instructed that under the doctrine of transferred intent, a person is nevertheless criminally responsible for causing a result if the only difference between what actually occurred and what he desired, contemplated, or risked is that a different person was injured, harmed, or otherwise affected. 10, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. 11, there is no limitation period for the offenses of capital murder or murder. Therefore, it is sufficient if the state proves that the offense alleged was committed sometime before September 27, 2022, which is the date the most current indictment was filed. 12, count 1, capital murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of February 2018 in Bexar County, Texas, the defendant, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did intentionally or knowingly cause the death of an individual, namely Benito Gallegos, by shooting Benito Gallegos with a deadly weapon, namely a firearm, and while intentionally or knowingly desiring or contemplating causing the death of Margarito Vigil and or Benito Gallegos, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, also caused the death of Angel Guevara, an individual, by shooting Angel Guevara with a deadly weapon, namely a firearm, and both murders were committed during the same criminal transaction, or the defendant, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did intentionally or knowingly cause the death of an individual, namely Benito Gallegos, by shooting Benito Gallegos with a deadly weapon, namely a firearm, and while intentionally or knowingly desiring or contemplating causing the death of Margarito Vigil and or Benito Gallegos, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, also caused the death of Angel Guevara, an individual, by shooting Angel Guevara with a deadly weapon, namely a firearm, and both murders were committed pursuant to the same scheme or course of conduct, but during different criminal transactions. And if you find beyond a reasonable doubt that the defendant was not acting in self-defense at the time that he committed both murders, then you will find the defendant guilty of the offense of capital murder as charged in count 1 of the indictment, and do not consider counts 2 or 3 as instructed in paragraphs 13 through 17. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of capital murder as charged in count 1 of the indictment, and next consider whether the defendant is guilty of counts 2 and or count 3, and proceed to paragraph 13. If you are unable to agree, you may still consider whether the defendant is guilty of count 2 and or count 3, which are lesser included offenses, to count 1 and proceed to paragraph 13. 13, count 2, murder, Benito Gallegos. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of February 2018 in Bexar County, Texas, the defendant, Richard Montez, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did intentionally or knowingly cause the death of an individual, namely Benito Gallegos, by shooting Benito Gallegos with a deadly weapon, namely a firearm, or with intent to cause serious bodily injury to an individual, namely Benito Gallegos, did commit an act clearly dangerous to human life that caused the death of Benito Gallegos by shooting Benito Gallegos with a deadly weapon, namely a firearm, or did then and there commit or attempt to commit the felony offense of aggravated assault, and while in the course and furtherance of or in immediate flight from the commission or the attempted commission of this offense, Richard Montez, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, shooting Benito Gallegos with a deadly weapon, namely a firearm, thereby causing the death of an individual, namely Benito Gallegos, and you find beyond a reasonable doubt that the defendant was not acting in self-defense at the time that he committed the murder of Benito Gallegos, then you will find the defendant guilty of the murder of Benito Gallegos as charged in count 2 of the indictment, and next consider count 3 as instructed in paragraph 16. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the lesser included offense of aggravated assault and proceed to paragraph 14. 14. As instructed herein, in paragraph 10, the phrase on or about means that the state is not required to prove that the alleged conduct constituting an offense happened on that exact date. However, the time of the offense must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The limitation period for the offense of aggravated assault is 2 years. Therefore, to be convicted of the lesser included offense of aggravated assault in count 2 or count 3, the state must prove that the alleged conduct, if any, constituting the offense of aggravated assault was committed at any time within the 2 years of the filing of the indictment in this case. The court has taken judicial notice that on May 10, 2018, an indictment was filed in the 187th Judicial District Court of Bexar County, Texas, under cause number 2018 CR 4785B, charging the defendant, Richard Montez, with the offense of capital murder, and said indictment was pending until August 1st, 2022. The court has also taken judicial notice that on September 27, 2022, an indictment was filed in the 187th Judicial District Court of Bexar County, Texas, under cause number 2022 CR 9260, charging the defendant, Richard Montez, with the offense of capital murder, and said indictment is still pending. The aggravated assault of Benito Gallegos is a lesser included offense of the murder of Benito Gallegos, and the murder of Benito Gallegos is a lesser included offense of the offense of capital murder as charged in the 2 indictments noted above. The aggravated assault of Angel Guevara is a lesser included offense of the murder of Angel Guevara, and the murder of Angel Guevara is a lesser included offense of the offense of capital murder as charged in the two indictments noted above. You are instructed that the jury may, but is not required to accept as conclusive any fact judicially noticed. You are instructed that the time during the pendency of an indictment charging the defendant with the same offense or a lesser included offense shall not be commuted in the period of limitation. The term during the pendency means that period of time beginning with the day the indictment is filed in a court of competent jurisdiction and ending with the day such accusation is, by an order of a trial court having jurisdiction thereof, determined to be invalid for any reason. Therefore, in determining whether the indictment in this case was filed within the 2 years of the date of the lesser included offense of aggravated assault, if any, you shall not commute any time during the pendency of an indictment toward the 2-year limit. 15, lesser included offense to count 2, aggravated assault Benito Gallegos. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of February 2018 in Bexar County, Texas, the defendant Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did intentionally or knowingly cause bodily injury to Benito Gallegos while using or exhibiting a deadly weapon, namely a firearm, or Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did intentionally or knowingly cause serious bodily injury to Benito Gallegos by shooting at or in the direction of Benito Gallegos with said deadly weapon, and you find beyond a reasonable doubt that the defendant was not acting in self-defense at the time that he committed this offense, then you will find the defendant guilty of the lesser included offense to count 2 of the aggravated assault of Benito Gallegos, and next consider count 3 as instructed in paragraph 16. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are able to agree, you will find the defendant not guilty of count 2 and next consider count 3 as instructed in paragraph 16. 16, count 3, murder, Angel Guevara. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of February 2018 in Bexar County, Texas, the defendant, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, while intentionally or knowingly desiring or contemplating causing the death of Margarito Vigil and or Benito Gallegos, caused the death of Angel Guevara, an individual by shooting Angel Guevara with a deadly weapon, namely a firearm, or while intentionally or knowingly desiring or contemplating causing serious bodily injury to Margarito Vigil and or Benito Gallegos, committed an act clearly dangerous to human life, to wit, shooting Angel Guevara with a deadly weapon, namely a firearm, and thereby caused the death of Angel Guevara, an individual, or did then and there commit or attempt to commit the felony offense of aggravated assault, and while in the course and the furtherance of or in immediate flight from the commission or the attempted commission of this offense, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, shooting Angel Guevara with a deadly weapon, namely a firearm, thereby causing the death of an individual, namely Angel Guevara. And you find beyond a reasonable doubt that the defendant was not acting in self-defense at the time that he committed the murder of Angel Guevara, then you will find the defendant guilty of the murder of Angel Guevara and as charged in count 3 of the indictment, and do not consider paragraph 17. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the offense of the aggravated assault of Angel Guevara, which is a lesser included offense to count 3 as instructed in paragraph 17. 17, lesser included offense to count 3, aggravated assault Angel Guevara. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of February 2018 in Bexar County, Texas, the defendant, Richard MONTEZ, either acting alone or together as a party with Juan Martinez and or Andres Martinez, while intentionally or knowingly desiring or contemplating causing serious bodily injury to Margarito Vigil and or Benito Gallegos, caused bodily injury to Angel Guevara while using or exhibiting a deadly weapon, namely a firearm, or Richard MONTEZ either acting alone or together as a party with Juan Martinez and or Andres Martinez, while intentionally or knowingly desiring or contemplating causing serious bodily injury to Margarito Vigil and or Benito Gallegos, caused serious bodily injury to Angel Gabar by shooting at or in the direction of Angel Gabar with said deadly weapon, and you find beyond a reasonable doubt that the defendant was not acting in self-defense at the time that he committed this offense, then you will find the defendant guilty of the lesser included offense to count 3 of the aggravated assault of Angel Gabar. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. You are instructed that if there is any evidence before you in this case regarding the defendants having committed offenses or acts of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any were committed. And even then, you may only consider the same in determining the intent or knowledge, if any, of the defendant, or to rebut a defensive theory if it does, and for no other purpose. You are instructed that under our law, voluntary intoxication does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance of mental or physical capacity resulting from the voluntary introduction of any substance into the body. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, LinkedIn, YouTube, Instagram, Google, or Twitter to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of the law made by counsel, if not in harmony with the law, as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, meaning all 12 of you agree, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict agreement. if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or convicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable verdict forms are attached. State, are you ready to proceed?
Yes, Judge.
All right, you may proceed.
Thank you.
What's that?
Oh, I'll pause the time. They'll
Okay.
connect it.
Thank
Deputy Laura. Thank you. IT was just here. This is what happens when IT comes, they disconnect things.
What is this on? Power?
Everyone, what I'm going to do is I'm going to give you like, not even really a 5-minute break, but I want to make sure that both sides are able to have the equipment up and running. So I'm going to give you all a 5-minute break in the hallway just to stretch. Do not start deliberating. Do not do any investigation work. You've received my instructions. Keep your badges visible. So I'm just going to have you wait in the hallway for just one moment, okay? All right, everyone, please rise for the jurors. Now it's starting to work. All right, that's okay. All right, so you want to, okay, awesome. All right, so we're just going to give them a little time to stretch their leg.
You can allow me to use your clicker. My clicker is. Okay. I can change my. I guess I'm going. Unless you allow me to. I'm just trying to fast forward. I have one as well.
Yeah. Speak back there in a minute.
Just the mouth.
Yes, we're just about to think this will be the first time we would stand. They're having problems with the technology.
Is this here?
Yes.
All right, and do you all both know how it's actually going to work?
It worked with IT earlier.
Okay.
Wishful thinking, Judge.
Put it on.
Oh, well, what's going to end up happening is we'll have to change that once you do that. So we'll change it from. So grab Renee. Okay, are both sides ready now? Okay, that was a long read, I guess.
Yeah.
Please be seated. And just so both parties know, we do have the full alternates, but they're not going into fact with the rest of the jurors. But I still have them, will have them under the court rules in case something won't happen anyway if you want to. So they will stay to the verdict, but they don't go back into deliberation. And just, I'm sorry, what is the time announcement for each party? Does anyone expect they'll need a time announcement?
I guess 5 minutes for you guys.
Just 3 minutes.
Yes. Announcements. Take a short break.
Yeah, I wore Depends.
That's only issue like that.
You know, I will tell you, that's one thing that, Janisa always told me. She said, whenever you can take a break, you need to take it because you never know when you're going to get the break again. Yeah. It works. She's getting it.
All right, for the jury.
And State, are you ready to proceed?
Yes, Judge, thank you. Good morning, guys. Let me give you a little brief rundown on what's going to happen. I'm going to speak for a few minutes, then I'm going to sit down, then the defense gets to speak. We each get the same amount of time, but James and I are splitting our time up. And then once they're done, James will wrap everything up for you, okay? The judge just read you that charge. That's long. That's one of the longest charges I've ever seen or heard. I've been doing this for 25 years. But I want you to keep in mind that this case is very, very simple. Did this guy and his friends have the right to shoot and kill two people? Angel and Benito. All it boils down to, okay? So let's talk about some things that the judge mentioned in the charge. Capital murder, murder, and aggravated assault. You'll see the capital murder is at the top, murder's in the middle, and aggravated assault is at the bottom. Aggravated assault would be if James is mad at me and shoots at me, he doesn't have to hit me, but if he shoots at me, that's aggravated assault. If he shoots and kills me, that's murder. If he shoots and kills me and Brenna, that's capital murder. Okay, it's very simple. All right. Now let's talk about something that also is in the jury charge, and it's at the bottom of this, but we'll start there, which is transferred intent. So, as we discussed, I believe that we even discussed it during jury selection. If James wants to shoot me, but misses because he's a bad shot and hits Brenna and kills her, well, it's still murder. All right. It doesn't matter who he hit. And that's the exact situation we have here, right? That's exactly what you guys are here to deliberate about. Let's talk real briefly about on or about. The judge mentioned that in the jury charge. There's been some testimony that the shooting might have happened right before midnight, maybe 11:40, 11:45. It's a little unclear exactly what time it was, but it doesn't matter per the indictment. The indictment says February 3rd. If the shooting happened 10 minutes before, 20 minutes before, it doesn't matter. On or about covers that. So please don't waste any energy thinking about that. The law is very clear about that. Voluntary intoxication, the judge also discussed that with you when reading the jury charge. I can get as drunk as I want or do as many drugs as I want, and it doesn't give me a free pass to commit crime. So even if you think that this guy was smoking meth 5 minutes before he was shooting, it doesn't excuse him of this offense, all right? Now, accomplice witness. It sounds very complicated and unique, right? You don't hear those terms very often. One is an accomplice witness, right? The young man that came and testified yesterday. He is an accomplice to the crime that Richard MONTEZ committed. All three of them committed the same crime. Andres, Juan, and Richard. They all committed the same crime. They're all guilty of the same crime, right? They all did it. Now, you have to, and in the instructions, it tells you, you have to not just believe what he said, but the evidence has to be corroborated. And you have multiple corroborations of what Juan told you. You have Brianna's testimony saying that she saw this guy out in the street shooting, right? You also have evidence that this guy was on the phone or somehow was saying that I put the guns up in the bathroom. I laid them out in the bathroom, okay? That's evidence that tends to corroborate what he says, and that's all the law requires. Don't spend too much energy on this, okay? Now, You saw the chart with capital murder and aggravated assault. If you find him guilty of the capital murder, your job is done. You don't have anything else to worry about. You don't have to go into reviewing whether or not it's a murder of Benito individually or a murder of Angel individually or anything like that. You do not have to waste any energy thinking about that. And the charge tells you exactly what I have on this printout, okay? It says, if you find him guilty of capital murder, you're done. And don't forget, as we discussed during jury selection, this is not a death penalty case, okay? So you're not here to determine whether someone goes to the gas chamber or something, okay? Self-defense. I expect that that's going to be part of their defense when they get up to talk to you. I expect it's going to be A, self-defense, and B, the kill shots came from a different gun that this guy wasn't firing, right? Let's start with the self-defense thing. Juan told you that there was no threat at that time. Brianna told you there was no threat at that time. There was no threat. You've seen the video of these little guys getting out of their car. Do those guys look threatening? Honestly, do those guys, one of them had a cane. You've seen photos of the cane next to the car. Benito had the cane. The victim had the cane. That guy came up and started mad dogging him and his two friends, each one of them who's got at least one handgun on them. Really? At midnight? Does that make sense at all? That makes zero sense. So there's no self-defense in this case. I'm going to remind you, do not do any research. And the reason we all keep bringing it up is because jurors have done this in the past here in Bexar County, and it's derailed trials, okay? Please do not Google the addresses. Please do not Google the names. Please do not do anything, any additional research than what you've heard from this witness stand or heard here in this court, okay? That's all you need to know. I'm going to sit down, and the rest of my time is going to go to James when it's his turn. But I just want you to keep in mind that no matter how thick that jury charge is, this case is very, very simple. Did this guy have the right to kill those two people? No, he did not. Thank you.
Defense, are you ready to proceed?
Yes, Your Honor.
Right, you may proceed.
Please the court, opposing counsel. Good morning.
Morning.
So the state gets to go first, and then I'm going to speak for a little bit, and then Orlando is going to talk more about the substantive issues, about the actual facts of the case. And then the state goes last. The state always goes last because they have the burden. They have to prove this case beyond a reasonable doubt. So I want to explain that and why they get to go last. Now, on behalf of Richard, Orlando, and I, we want to thank you for being on this jury and listening to the evidence. It's been a long trial. It's taken many days to get here, and we appreciate your attention and your time on this case and what you're doing in upholding the Constitution. I want to point out a few things that Mr. Kuntz talked about, and also point out a few things, other things in the jury charge. You're going to get to take that packet back with you. Okay, you can read it as many times as you want. If you have questions about anything, they're contained within that packet. That's kind of your guide for your jury deliberations. Okay. Now, in talking about accomplice testimony, you heard yesterday from the state's star witness who took that witness stand in Juan Martinez. You can also consider the fact that you didn't hear from the lead detective in this case. You didn't hear from any detectives in this case, but you heard from their star witness, Juan Martinez. And it's going to tell you right there in that jury charge that for accomplice testimony, that you cannot convict Richard MONTEZ unless you believe the testimony of Juan linking Richard to this case is true. You cannot convict Richard of capital murder unless you believe the testimony of Juan Martinez linking Richard to capital murder is true. Okay, so Richard, Orlando's going to get into this in a little bit, but you already know based upon the testimony of Juan yesterday that he lied to you. You know that based upon the ballistics. You can't refute science. You can't refute casings. So you get to judge and decide if what he told you linking Richard to this case is true or not. Okay, that's first and foremost. For you to find Richard guilty as a party to this offense, you have to believe that he solicited or encouraged or aided or directed or attempted to aid in the commission of this offense. If you do not believe, and if the state has not proven to you beyond a reasonable doubt that he solicited, encouraged, directed, aided, or attempted to aid Juan Martinez or Andres Martinez, you must find him not guilty. There's a section in the charge talking about self-defense. And we heard the testimony from Juan yesterday that he pointed a gun at the two individuals because he believed that they had a gun. There doesn't have to actually be a gun pointed at you for you to have a self-defense, okay? It is what we call apparent danger, okay? What you believe in what Richard believes in his mind on February 2nd, 2018, in regards to him being in apparent danger. It doesn't have to be actual danger to be self-defense. So it's from Richard's standpoint, from Richard's point of view on February 2nd, 2018. Now, like I mentioned at the beginning, the burden is beyond reasonable doubt. That is always on the state, okay? That never shifts to us. We don't have to prove the self-defense claim. The state has to prove beyond reasonable doubt that Richard was not justified in using self-defense. Now, we talked about in jury selection, we had that kind of pyramid showing preponderance of the evidence is right here. And then we go to clear and convincing evidence, and then beyond reasonable doubt is all the way at the top. That burden is the highest in this state. It's the highest in this country, and it's above clear and convincing evidence. And that's when we talked about the amount of evidence that they would need to take your children away. Well, beyond reasonable doubt is higher than that. So when you go back and deliberate, you have to decide if the state has presented evidence that proves to you beyond reasonable doubt that Richard committed this fault. There has been testimony and images, body cam videos in relation to Angel Guevara that were very hard to watch. It's not easy to see, seeing a 14-year-old dying. But you cannot let your bias, sympathy, or prejudice play any role in your deliberations. You can't go back there and say, I don't think the state has proven their case beyond a reasonable doubt, but man, a 14-year-old kid died. Can't do that. Your job is to uphold the Constitution and to hold the state to their burden. And if you do not believe that they have proven this case beyond reasonable doubt, regardless of the deaths, then you must find Richard not guilty. Now, you heard testimony that Juan Martinez, Andres Martinez had pled to this case. You're not to consider the fact that they pled these offenses as any evidence of guilt towards Richard, okay? The only thing you can consider is that Juan Martinez agreed to testify against Richard in exchange for his plea, in exchange for what he got. Now, evidence is what you heard from that witness stand. These photos, all these exhibits in this cart right here, that is evidence, okay? There were police reports that were marked that you will not get back. Can't ask for any certain police reports. The only evidence that be brought back to you is the evidence that you can consider in this case. And now, lastly, your main job as a jury is you get to judge whoever takes this witness stand. You are the sole judge of their credibility. So you heard what Juan testified to yesterday and the day before. You get to judge what he told you and whether you believe it or not. You get to judge the testimony of Brianna and Isabel Rodriguez, the daughters of the ex-girlfriend of Richard MONTEZ, and whether they told you the truth or not, or whether what they believe they saw was the truth or not. So you get to judge their credibility based upon what they testified to. And so I'm going to sit down and I'm going to let Orlando address some substantive issues. Thank you.
Good morning. Like Mr. Piddle, Kelly said, we thank you for your time here. It's been very important. Kind of felt like, I don't know if you've seen the movie The Judge, but as I walk up to the courthouse, I feel like throwing up. Right, this is a very serious case. We can't change the past. Nothing's going to bring back those two people. Only thing we can do is make sure that justice is done right, and that we uphold the Constitution, that we hold the state to their burden. And the state is right. This is somewhat of a simple case. And the evidence is pretty clear as to what happened here. It's going to require you to look at that evidence and kind of consider, as we go through it, what happened that day. And so, we understand that there was 2 bullets in this case, right? And 1 gun that caused the death of those 2 people. And Richard MONTEZ didn't fire those fatal shots, right? We understand that he didn't fire those shots. Now, as I said at the beginning of this case, you have a profound power and responsibility. Your decisions should not have emotion that take into effect of your deliberations. Your job as jurors is to look for reasonable doubt. Now, the truth is not always clear, right? The truth, as we know it, is sometimes mixed with falsehoods. Falsehoods either because of bias, because we want to see things a certain way. The truth is sometimes mixed with falsehoods because we're trying to protect ourselves. Sometimes it's because of mistake. Eyewitness testimony, we're going to go over that a little bit, is sometimes wrong. What's typically not wrong is science and what the evidence is. And so the state has to prove beyond a reasonable doubt what the truth is, right? And we talked about that. And so how are they going to do that? They brought you witnesses. We're going to go through the list of those witnesses and what they did and what they didn't do. I want you to go back to the jury room and say, could they have done more? Could they have brought us more information? Because I assure you it was out there. I assure you they could have done that, but the state failed to do that. Now, the sister's testimony was incredible. They said some things to us, right? That first question, not a fan. Immediately, that tells you what? Bias, right? Already know that these individuals do not like him. They stated that Richard was the only one in white. Stated that the shooting was in the middle of the street. That the Castellano courts aren't dangerous or not a high crime area. They said something to that effect. And we heard testimony from witnesses that counter each of those statements. First off, we see that Juan Martinez is wearing white. Richard MONTEZ is not the only person wearing white. Not only is Juan Martinez wearing white, he's covered in GSR. Now, there's no evidence of shots fired in the street. This is the diagram that they took of all the evidence they collected, right? And so there's pictures. There's over 200 pictures. There's casings. They closed off the streets. They took pictures down the street of Picoso. They didn't find any casings. And allegedly, Richard MONTEZ was running down the street with a rifle. We know that did not happen. We know that he did not fire a rifle. And if you look at that diagram, you'll see a pattern of shots, and we'll go over that. But there's a pattern, that pattern tells you a story, right? Because when people are moving and they're firing shots, they leave a trail. And the state said in their opening statement, a trail of bullets. They weren't speaking about a trail of bullets in the street. This is the trail of bullets they were speaking about. Now, they brought you CSI Officer Patton, who collected the evidence, and there was other people. She was in charge of collecting that evidence. She told us the Calciano courts are a dangerous area. It's first witness to say that. She was not the only witness. It actually sounded, as they brought us other witnesses, that they target this area. This area takes up most of their time. That contradicts what the Rodriguez sisters were saying. Now, why would they say that if they weren't trying to mislead you? She said she would have done the trajectory rods differently because if you look at them, they don't seem to be in the proper position. She said that they need, 2 points. And so I asked you, if you look at those pictures, to not use those to determine exactly the position as to where those bullets entered, right? She said she would have done those differently. And I don't believe that evidence is credible. They could have done line tracing, and that would have been from where shots were fired, and they could have taken lines from each area of where those shot casings were. And they could have taken a line all the way to the window of 203 St. Christopher Walk. And they could have excluded areas in front of 928, in front of 930. They don't collect data to reconstruct that shooting, right? So they don't collect the height that's to what it entered. They don't collect the angles to which the bullets entered into any of the buildings, into the vehicles. And she reported to a lead detective, right? We know that in a homicide case, there's a homicide detective. He's going to be in charge. She was in charge of collecting the information, but she reported to a lead detective. The lead detective wanted her to bring him more information. She would have gone and done that. So we had CSI Officer Starr come and testify. He did a diagram inside 203 St. Christopher Walk. He did no angle measurements. He also did no line tracing. He talked about that. And so we talk, why is line tracing important, right? And so we see a picture of 928 Angela Walk, 930, and 932. And the diagram corresponds to those 3 sidewalks. And you're going to see where there are casings, mostly 40 caliber casings, left there. And from that position to where 203 is, we have no idea as to where it was possible for that bullet to travel, because there are buildings that would block or obstruct that view from a certain position, right? And so they didn't bring us any of that line tracing to tell us to exclude areas. So we don't know where the bullet came from. It was from 928, 930, 932, right? They called officers. They called a lot of officers. Called 13 officers, right? Casanova said a high crime area. Hernandez said they had directed patrol. That's what they looked at. They went to the convenience stores before their shift, got their snacks for that day or night, and they spent most of their time in that area. And those girls said that it was not a high crime area. That's not the truth. So they brought you 13 officers, but who didn't they call? Right? No detectives, not one that interviewed Juan Martinez. Though Juan Martinez testified. They didn't bring you the detective that interviewed Andres Martinez. Juan testified he had the Glock. They didn't interview George Martinez, another person he said that was at his apartment that day that was taken into custody. They didn't bring in the detective that interviewed Chino, who was at the apartment. And they didn't bring in the detective who interviewed Richard MONTEZ. And they could have brought you that detective. They could have brought his statement. They didn't do that. And it's not because we hid that statement, right? It's if they had that statement, they could have brought it to you and you could have heard it. What's even stranger is they didn't bring you the lead detective. The lead detective is in charge of the entire case. We could have questioned him. What was the credibility of the 3 witnesses that were interviewed? 4 witnesses that were interviewed? Were there any corroborating stories? Right? We could have learned something. We could have garnered something from that. And mind you, this is the state's case to prove, not ours. The burden never shifts from this table, right? They have the burden. They have to strip Mr. MONTEZ of his presumption of innocence. They also had DNA evidence. We heard that they collected blood DNA samples. We heard that they collected trace DNA from the triggers of the weapons. No evidence presented, right? They could have done more. They could have shown you more. Holly Warden, she was the firearms expert. And she went through, she determined what casings were fired from which gun, right? Which is important because we need to know what happened, right? What caliber caused the death of those 2 individuals? And so I asked her, if you were told that there was an AR-15 that was fired in this case, would you believe them? Would you have your doubts? And she would not. She would have problems with that, right? Because there's no evidence that was collected. And we saw that the whole crime scene was taped off. They said they did that to protect the integrity of that crime scene. There's no evidence of any .223 rounds. And there's 24 rounds of 40 caliber shell casings, right? All from one gun. All from one gun. The Glock 40, right? That's the gun that fired 24 rounds. That's the gun that fired 2 bullets that caused the death of 2 people from one gun. Bashan was the GSR, CSI, not CSI, but the lab tech, and she brought you results. Juan Martinez had the most GSR. Andres Martinez had the second most. Richard MONTEZ had the least, right? He had the least. What does that tell us? That there was obviously gunfire, right? Possibly gunfire, that they were around gunfire. Now, it stated if you're in an area where there's a lot of gunfire, you're going to probably have more. They didn't test the back, which I thought was a little strange. I've been in cases before where they'll test even the back pockets to see whether someone had a weapon in their back pocket, right? They tested the shirts, they tested cuff areas, confirmed that there was GSR on cuffs, GSR all over Juan Martinez. And so, what does that tell us about Juan? Tells us that he was present, right? And if there's a lot of shots going on, either he had the gun that fired a lot of these shots or he was around them, right? He says he went upstairs. And that story we'll go over, but something's a little off about that story. Now, what's a little off is those 2 markings there. That's the diagram and the 2 shell casings, item 12 and 40. Item 12 is in front of 928. Item 40 is in front of 932. And those 2 casings come from a 9mm Millennium Taurus, which Juan says that he had. He says he didn't fire, but there's 2 casings, not whole bullets, not unspent rounds, 2 casings that Holly Warden confirmed came from the 9mm Taurus. Now, if you recall, when I questioned him, we talked about he didn't listen to a statement before he testified, talked to the state a couple times, and for the first time gave some testimony that we heard about. But he listened to a statement and said, well, you're right, I didn't let them know right away that I had 2 weapons. Juan Martinez, he says these things to us. and this is important. He says it was all day people threatening to come by the house. I asked if you had a gun, you were prepared to do something. He said, yes. He said he was from Califas. My uncle owns the streets. He's talking about these two people who are approaching the streets, or the two individuals on the street. We didn't hear any testimony about whether anybody was using a cane at the time, right? So whether anybody was using it as they walked or not, they didn't elicit any of the testimony to help us understand whether or not he even needed that cane. We did know that there was other items, or at least another item in that vehicle that possibly could have been used as a weapon or appeared to be a weapon. But he says he had a bulge. It looked like he was reaching for something in his waist. I said, don't reach. And then he said, no one said it the first time he testified, the first day. He went through his testimony, his statement to the police, and he said, yes, I did say that. He said everyone else said it too. And why is that important? Because it shows a shared concern. It showed everybody thought, hey, this guy's reaching. He says, I was scared, so I pulled my gun. Now, they want to cast off as though Richard MONTEZ was intoxicated. That's a red herring. Right? They want to say that it was because of his mental state that all of this happened. We didn't hear anything about Juan Martinez being intoxicated to the point where he was agitated, paranoid. He was the first to pull his gun because he was concerned. They went back to the car, and I questioned about that. It only took about 10 seconds. He didn't know what was going on. He didn't know what they were going to do. The state, after talking to him, in exchange for his lesser sentence, because a capital is life without parole. That's what we're here about, right? In exchange for his lesser sentence, he tells you what? Oh, everything was fine. Everything is kosher. Well, question him again. He says, well, I didn't know what they were going to do. He heard a gunshot. There's evidence that there was a shotgun there, right? There's evidence that a shotgun was fired because we see the plug down the street, the wad. The wad of paper in that shotgun shell is down the street. It's pretty certain in my mind that there was a shotgun fire. There's several shells there. You can look at the pictures. Evidence was collected. Shotgun shells were there. They didn't test them. There's no real way to test it without an actual shotgun. They didn't recover a shotgun. He says, I was alarmed, right? He heard the shot. I was alarmed. What would you do if you heard a shot? If you already thought somebody's in possession of a gun and you don't know where that shot's coming from? And we talked about his statement on the stand where he said that, he gave a proffer, which was a statement to the prosecutors in regards to what he saw. This is what I will testify to in exchange for this plea. But he also said it there before he knew any of what was going on. He said he wasn't even aware that somebody had got shot when they got arrested. So he's telling him, well, my cousin had a Glock 40 and he's known his cousin. He's living with his cousin. His cousin's living with him. He's known Richard MONTEZ for a couple of days. Who do you think he's going to try and protect more, right? Family or somebody you just met? He thinks that Richard had an AR-15. Tells you the detective actually said, hey, AR-15, that bullet's going to travel further. And in his mind, he's thinking, I suggest to you that my cousin, that it must have been an AR-15. My cousin's okay. Says that Richard had an XD 9mm in his holster. I asked him about that. And the officer had asked him, are there going to be any 9mm casings on that crime scene? Because I haven't gone there. And he says, thinking, oh, shoot, I fired a couple of shots. Maybe that's what he's thinking. But he certainly says, Richard, oh, yeah, I remember Richard had a 9mm, making sure that he accounted for everybody else, right? Making sure I'm not the only person that had a 9mm. He says Richard fired his rounds and stopped. Says he went inside and got the AR-15. Right? Which the evidence kind of supports. You know, look at those casings and the evidence supports that. Says, I didn't see all the shooting because I was upstairs. I glanced at it. But somehow he saw Richard running down the street. Somehow his casing was down the street. Remember, he's the person in white. And initially testified, well, Richard was running down the street. Well, okay, it was the corner house, which the evidence supports. The casings are there at the corner. And any eyewitness testimony that, you know, somebody was down at the corner in white could also lead to Juan Martinez being there. What supports that? Juan Martinez gun casing, right? And so what do we get from Juan? Richard didn't have the weapon that caused either of the deaths. And it's uncontroverted, mind you. The state brought him that witness, brought you that witness. And it is uncontroverted as to who had the Glock 40.
We have to object. That's a mischaracterization of the evidence.
All right, ladies and gentlemen, you will remember the evidence as you received it.
Andres fired first. He said this at the police station. He said it to us in the proffer, as he stated on stand. He stated it to you. Andres, I think, fired first. He does say, I don't know really who fired first, but he thinks that Andres fired first. Richard fired one series of shots. He tells you that, right? He tells you he fired, and I guess he must have fired all his shots because he went in to get his AR-15. Meaning that Richard fired from that position, retreated into the house, got the rifle, which people say they saw him with. Okay, that makes sense. Richard was in a position to be afraid for his life, just like Juan was. They were there. They were on their own premise. These people came to them. No evidence has been brought to you that they were doing anything illegal at that time, that they were involved in any criminal activity. No evidence was presented to you. Now they're going to suggest to you that Richard provoked that situation, that he went up to those individuals. They're going to say he provoked that situation. Well, those individuals walked off. Something happened. A gunshot went off. At that point, I would say that Richard did not have any involvement. There's no evidence that he provoked the situation. And there was some testimony that Richard actually went to those two people's car. Well, we learned that there's actually another car parked in front of 928, right? We saw the gray vehicle that, and I don't know if I displayed it to you, but I pulled those out real quick. Juan identified, yeah, that's my neighbor's car. That's my neighbor's car in front of 928. It's gray. It's night. It's dark. Sister said, I saw them out by a gray car. Whether I think the state is trying to suggest to you that Richard went to the corner by the dumpsters and he approached that vehicle over there. And the evidence doesn't support that. Juan cut a deal to protect himself, right? That's another thing that we got from him. We learned from him. So, well, when you were there at the station, you weren't trying to protect your cousin. You weren't trying to protect Richard. You weren't trying to protect anybody but yourself. Apparent danger. It's not necessary that there be any actual attack or attempted attack, right? So that's what we talked about a little bit. It's in the jury charge. That it does not have to be an actual attack. It's from the viewpoint at that time. And there's 3 people there that believed that there was a possibility that they were being shot at, or at least Richard did. So Richard didn't fire first. Richard heard a gunshot, according to the evidence. The evidence is going to support the position that he responded to that. Now, they have to prove beyond a reasonable doubt that Richard acted as a party to all this. It's a perceived danger, right? It's from that person's position, what do they perceive? they have to prove, the state has to prove beyond a reasonable doubt against self-defense. Okay? It's their burden to prove beyond a reasonable doubt that they did not, or that Richard did not act in self-defense. We talked about this at Void Dyer, how we can go in and do things, and maybe we both want to buy lottery tickets. Does that mean that we both get to get the prize, right? Threats. So what was the apparent danger? Threats from earlier in the day. 2 strangers own these streets. He says he doesn't really understand what's going on because they're talking Spanish, but he hears something along those lines. Own these streets. Well, that sounds kind of threatening to me. Reaching for the waist, had a bulge. There's a rebar and a cane that from a distance could appear to be a gun. And so they go into the car and reach for those 2 items. It's reasonable to think that maybe they do have a weapon. No offense to police officers, but they shoot people all the time for less. The sound of gunfire is another factor that creates apparent danger. All those factors together create apparent danger. Andres Martinez, let's talk a little bit about Andres Martinez. We didn't hear from him, right? The state alludes he has a different story in question. Well, you were aware that he had a different story, right, about who had the gun, but they didn't call him to testify. They could have called him to testify. We could have heard, oh, who else do you think might have had that gun? They didn't do that. He pled and has been sentenced. The person who is known to have the gun that caused these 2 deaths, he's already been sentenced. They never controvert that Andres had the Glock 40. I didn't hear any evidence to say that. We could have also learned from Andres Martinez whether or not he was acting on his own, whether he was told, let's do this. He's the one who's responsible. He is the party responsible for those deaths. And we have no idea what was going on in his mind. They could have called him and proven to you that, hey, you know what? I was doing this because of Richard Martinez. MONTEZ, I apologize. They didn't do that. They could have done that. They could have brought the detectives. Did Andres and Rich, did Andres act because of Richard, right? That's what I was talking about. Do we know beyond a reasonable doubt that Andres acted because of Richard? Do we know that Richard, beyond a reasonable doubt, acted because of Andres? Juan says he thinks Andres shot first, but there was also shotgun shells and a shotgun wad. We talked about that already. Now, there's 2 series of shots taken. I circled, and this is in the position of the way the Google map that they presented as evidence is positioned to you. Although it's upside down, you'll see at 9:28, there's a series of shots. Circled are all from one gun, the XD 9mm. Now, as we look at
5 minutes.
As we look at these pictures, we see a pattern of shooting. And if Richard then takes a step back, it looks as though someone then continues shooting on their own, continues and shoots more. And from 9:28 to 9:30, there's shots at 9:30. And those could have been the fatal shots that hit Guevara after Richard had already stopped shooting. They could have been, and most certainly likely, that the shots taken at the corner were the shots that killed Benito Gallegos. Now, there's evidence that Richard actually was firing up in the air. So did he even shoot at anybody? We heard from their first witnesses that they saw him shooting in the air. That seems as though it's to scare somebody off. Is Richard responsible for Benito's death? Gallegos was shot from behind. You'll see in the car, there's a windshield, and then the headrest, a hole into the head. That is a shot that's more in line, having been shot from the corner than from where Richard was standing in front of 9:28. Wasn't shot from the side, wasn't shot from an angle. And although they said that the car was at the dumpster, if Richard was not shooting in the air, he was shooting at the vehicle. He would have been shooting not at the direction of Angel Guevara, which is down over 203 St. Christopher, but he would have been shooting at the dumpsters, which was in line with Angela Walk. Angel Guevara shot by a 40 caliber bullet. The bullet entered from an unknown angle. There's reasonable doubt that we don't know at what point, at when in time that this was going. We know there was 2 series of shots. And I suggest to you that it was the second series of shots that quite possibly caused the death of Angel Guevara. The state has not proven beyond a reasonable doubt that Richard MONTEZ did not act in self-defense. We talked about parties. We talked about in Boyd Dyer, 2 people decide to play a game, a ring toss. One person stops, the other person continues. The person who stopped, he doesn't get to share in that prize. The state's trying to sell you something that isn't right. We don't even know why Andres Martinez acted. They could have brought you that. The state has not proved beyond a reasonable doubt that Richard caused the death of either person. Andres Martinez fired the fatal shots from his Glock 40.
2 minutes.
The state has not proven beyond a reasonable doubt that Richard is responsible for Andres Martinez's actions. Now, Juan Martinez didn't cause the death of either of those 2 people either. And so it's a question as to whether Juan Martinez should have pled to this or not. That's his own choice. He makes his own decisions, right? There's some evidence to support that maybe he was down the street or down at the corner. We don't really know what was going on, but they didn't prove that Richard was responsible for Andres's actions. Because of that, we ask that you find Richard MONTEZ not guilty of all 3 offenses. Thank you.
State.
If I can have a moment. May it please the court, defense counsel.
Yes.
Why doesn't someone do something about it? I think at some point, all of us, we've watched the news, we've watched television, we've read the newspaper. We've seen, we've heard, we felt violence that was senseless. And we asked ourselves, why doesn't someone do something about it? And ladies and gentlemen, that is why we're here. We are here to do something about it. 2 of the 3 have already pled out, and there's just 1 guy left, and that's him. Now, you've heard the defense counsel. We're going to go over a lot of things because it's important to understand, remember the facts as you remember it, because a lot of things that they said aren't quite accurate. And a lot of things that they talked about the law, they left a few parts out. And so we're going to cover all those things, but understand why we're here. We are here because there is constantly senseless violence. And it's real easy just to think maybe, that's just the way it should be. That maybe that's just the way we have to live. But when people don't do anything, things don't change. And that's why we have to do things. We wouldn't be here if Brianna hadn't come forward and identified where they were. We wouldn't be here if police officers didn't do their job. And we are here because he is the 1 guy left. And he is the ringleader. It wasn't Juan Martinez, who was 18 at the time, or his 20-year-old cousin. It's him. He's the guy in charge. When you hear that 911 call, he's the one making the calls. Now, we've heard about their self-defense argument, and I'm going to go into that. But it's important to understand, he keeps saying there is no evidence of the 40 or blah, blah. They don't deny he shot. They're just trying to make some self-defense argument. And they're trying to sit there and say, well, he wasn't the one with the 40. Well, we made it clear with Juan. Andre says he had the 40. And they're sitting there and trying to put the 40 caliber in each other's hands. And when we talk about the law, and we'll get to that, It doesn't matter, okay? It makes no difference who had the 40. They can claim the other one had the 40 all day long. If you're a party, and we're gonna get to that, in for a penny, in for a pound. And if you're part of something, guess what? You're guilty of it, whether you do anything to aid, encourage, solicit, or direct. Now, when we talk about what happened that night, and we're going to go into it, the Castellano Courts is public housing. It's a situation where there was violence on that day. And that's why we're here, and we're here to talk about capital murder. Now, the charge is very thick, but it's important to understand, what is capital murder? Capital murder is the murder of more than one person. That's what it is. It's the murder of Angel Guevara and Benito Gallegos, either acting alone or as a party with Andres and Juan Martinez. Now, why does that matter? Party language? Need my glasses to read that one. Under the law of parties, a person is criminally responsible for the offense committed with the conduct of another, if acting with the intent to promote or assist the commission of the offense. He solicits, encourages, directs, aids, or attempts to commit the other person to commit the offense. Remember when we talked about in jury selection, if 2 or 3 people shoot at someone and we don't know which one of them actually shot him, it doesn't matter. Under the law of parties, they're all guilty of the same thing. One of them may be a better shot than the other, but it doesn't matter if you aided or directed or encouraged. And what did you hear about aiding and encouraging? This defendant came home with a bag full of guns and handed them out. Right before, when they were trying to leave, Benito and Margarito, what do you say to them? We have to take them out. They're going to come back. And despite the fact that they keep trying to sit there and say that he wasn't shooting or he wasn't the one that pulled the bullet, it makes no difference. And they're doing this thing with the angles and stuff. And you have to understand, that's what criminal defense attorneys do. No matter how much evidence there is, no matter what there is, they always want more. They keep talking about, well, what about line tracing? Well, what did Lindsey Patton say? But you got to know a lot of things. You got to know where the car is and where they're standing. And if they're moving, there's too many factors to do that. But they always want more because that's what they're trained to do. If someone doesn't testify like the detective, why did the detective come? What did the detective do? In real life, who does all the work? The CSI people do all the work. They're just directed by the detectives. And he's like, well, the detective interviewed person. Or you think they can just tell you what the person said? No, it doesn't work like that. And a lot of times, as we talked about in jury selection, people disappear. People don't want to get involved. People don't want to testify. But we're here because a few people did, Brianna and Isabel. But it's important when you talk about the law of party, it's not just whether or not he did it, but did he do it with other people? Did he do it? Was he part of a group that did something? And if you remember, not only Juan Angel Martinez saw him shoot down, but Brianna, she's recognized the car and she saw him shoot down. And it's one thing. Remember, shell casings eject to the right. So they keep talking about this diagram, but remember, when you're familiar with guns, casings eject really back and to the right. So wherever it is, that's not quite where it is. It's just, so they would be in the street. And so I'm not sure where they're going with that. But remember, under the law of parties, you're guilty if you're in part of it, if you're doing it with a group doing something. If you do it to aid, encourage, or direct, you're as guilty of the same offense, not a different offense, but the same offense. Now in the charge, there's lesser included, if and only if you're unable to reach a verdict on count 1, capital murder, or if you find them not guilty, then you consider count 2 and 3, which is the murder of Benito Gallegos and the murder of Angel Guevara. And if and only if you can't reach a decision on counts 2 and 3, then you consider just aggravated assault. Did he just shoot at them? And so that's how it works. You consider the top charge first of capital murder, and then just murder, and then aggravated assault. John talked to you about honor about. I just don't want you to go back there and belabor that point. Honor about means state's not required to prove the alleged offense happened on that particular date. It's sufficient that they prove the offense was committed sometime before September the 27th. We do this because sometimes there's some confusion about when something happens close to midnight. And then when someone doesn't die until the next day, or someone dies a week later, the exact date does not matter. As long as it was before the date of September the 27th, that's all that matters. And so don't worry about the date. And John also talked about the accomplice witness testimony. Don't worry about that. They keep talking about that. It's not really a big deal. When an accomplice like Juan Angel Martinez testifies, there just has to be some evidence that tends to connect the defendant to the crime, independent of him. That's it. It doesn't have to independently prove his guilt. There just has to be some other connection. And the fact that he told the police officers, these are where the guns are upstairs, that connects him to the offense. Brianna saying that he shot, that connects him to the offense. Isabel seeing him shooting in the air, and then second shots later, seeing him with a gun, that also connects him to the offense. The accomplice witness testimony rule is really not something that you should think about. He also talked about causation, about transferring intent. A person is responsible for the offense if the only difference between what actually occurred and what he desired or contemplated or risked is that a different person was injured. And we talked about this in jury selection. Remember, intent follows the bullet. It doesn't matter if you hit somebody that you weren't aiming at. You're still guilty of what it is you did. If you're trying to murder someone or try to hit or injure someone, and then you miss them, you hit someone else, you can't claim it's an accident. It doesn't work like that. You're guilty of a crime. Now, in terms of murder, remember there are 3 different ways about committing murder. As a party, if you intentionally cause the death of someone, or acting as a party, you or not, you commit an act early danger to human life, or while attempting to commit an aggravated assault, commit an act early danger to human life. Those are just the 3 different ways of committing murder. We also talked about the fact that voluntary intoxication is not a defense. Something I noticed that the defense never once talked about. Look, we know methamphetamine is a problem in our community. We know ice is a problem, which is the street name for it, but people still use ice because when you use ice, you feel confident, you feel energetic, you feel like you can do anything for days. The problem is what happens when you come back down from ice? You get paranoid, you get violent and aggressive. And sometimes you begin to hallucinate and see things that aren't there. And so is ice a problem? Yes. But the fact that he was using ice, not a defense. Now, they keep talking about self-defense, and that's, I think their argument is that somehow it's self-defense, and we're going to go into that more. But they left a few things out, okay? The law will give self-defense deadly force to people, but it's going to be in very narrow situations. You're justified in usually deadly force against another if you would be justified in using force when and to the degree you reasonably believe that deadly force is immediately necessary to protect yourself against someone's use or attempted use of a law. They keep talking about, well, from his perspective. No, yes, it's from his perspective, but it's from a reasonable person in his perspective, not someone on meth, okay? He has to have a reasonable belief. So is it reasonable to believe that 2 guys, the 160-year-old, 169-year-old, walking away is somehow a threat? Is that reasonable? Not just from what he thinks. Is that reasonable? Was there an immediate threat? You saw the bullet in the back of the glass. Where's the immediate threat when they're trying to get away from this crazy guy? And you have to protect yourself from someone's attempted use or of unlawful deadly force. So which means someone's trying to commit a crime against you and using deadly force against you. Well, what evidence did you hear about Benito and Margarito using deadly force? There's no evidence that they had a weapon, a gun. What is cane? Was his cane a deadly weapon? And so they just sort of gloss over that. And how are they somehow being unlawful and being criminal? They got lost and they ended up in the wrong place and they paid for it because they ran into the wrong person. Because whether we want to realize it or not, there's a lot of senseless violence in this world. But remember, in deadly force, there has to be a reasonable belief, not just what he thinks, that is immediately necessary to protect yourself against someone's use or attempted use of an unlawful deadly force. And there was no deadly force used by Benito or Margarito. There's nothing that they did was unlawful. And there's certainly not anything reasonable about shooting them or shooting their car as they're trying to get away. Now, we know shell casings eject to the right. And I know they keep trying to make a big deal about the fact, but if you look at it, if shell casing ejects back and to the right, you can tell they were shooting at some point in the street. Some of the shell casings would indicate that. And from where you are, you have a clear line down that street and shoot. And that's where our story begins. When the police officers came, you heard from Officer Pollard. And Officer Pollard said, look, we were at the convenience store. And all of a sudden we heard 15 to 20 shots. And so what did he do? I mean, they kind of swarmed in there. And they kind of hoped that no one got hurt, right? They saw it. They saw bullet holes. In fact, they went to 202 St. Christopher and they saw more bullet holes. And luckily, they didn't hit anybody. And at first, they were optimistic that maybe no one had gotten hurt. But then they went to 203 St. Christopher. And that's when they learned the horrible truth about what happened to Angel Gabar. And I'm not going to belabor that. You saw the van being hit. I mean, the bullet marks were everywhere. We saw how he looked. He was just a kid in his own home, minding his own business. And then when the cops came out, they found all these shell casings. In fact, one officer told you he accidentally, well, not accidentally, he parked right in front of their home, not realizing it was the home. And then when Brianna came forward and Isabel and identified that that's where they were, he had to remove his civilian person. But they all told you, they could smell the gunpowder in the air. They could smell it. And they knew that they were there somewhere, but they didn't know where. And if people don't, in these communities, in any community, if you don't come forward, if you don't help the police, they can't do their job. But Brianna did. And because she told them they're at 928 Angela, they formed a circle around there. And they couldn't they couldn't run. They couldn't get rid of their weapons. They couldn't do anything except try to play dead. And that's what they did for 9 or 10 hours. Now, I think one of the questions they tried to ask was, well, I mean, weren't they instructed? No, they weren't instructed. That's what one of the other officers said. There was a negotiator. They tried to talk to them. It was only at the very end, once they were able to breach, when SWAT had their armored vehicle and they were about to go in there. That's when they called and said, all right, we're willing to come out. And like, okay, well, that's fine. But why are they hiding? What are they trying to do? I mean, I think it's pretty clear. We know this, from the Bible, only the guilty shall flee. They fled, they hid, they tried to hide. You know who didn't flee? Margarito didn't flee. Benito didn't flee. They're the ones waving down the cops and said, hey, man, we need help. But they hid and they tried to hide from the cops. And they only came back out when they realized the cops weren't going away. And inside the car, inside the house, right where the defendant told him, he told her. Remember, the officer told him, he talked to him when he came out. He said, look, the weapons are in there. He made some vague statement about trying to protect his own. But the rifle, the handguns, he tries to, I'm not really sure what argument they were trying to make about the rifle, about no one saying that there were people, Brianna, who saw him with the rifle. And if you remember what Holly Warden told you, not just all the shell casings matched the weapons, but there was a live round of that matched that rifle with 2 indent marks on it, as if someone had tried to fire it, but it had jammed. Now, for those of you who know about that,
Judge, there was no evidence that was the case.
Ladies and gentlemen, you will hear the evidence as you received it.
now, when you have a weapon that jams in a rifle, what do? You pull back the action, the slide, and you clear it out, and it ejects the bullet that was blocking it. And what happens, most people do. Most people, when we have a jam, we pick the live round off the ground because that's the responsible thing to do. Did he pick up the live round on the ground? No. I mean, it's on the map. It's right there where he ejected, and he never bothered to pick it up. He just left a live round on the ground in public. And when we look at how far Margarito and Benito got, they didn't get very far. And we got a couple blocks away. And when we look at their car, you know, when they were stopped by Officer Ramos and Officer Hernandez, they didn't even notice the gunshot at first, but they did later on. Right through the back, right through the headrest, killing Benito Gallegos. And he has to, I've asked you to try to claim that that's somehow self-defense. How's that self-defense? Killing an unarmed 69-year-old man while he's trying to get away. You know, self-defense, there has to be an immediately necessary to protect yourself against someone's use of unlawful deadly force. What deadly force was there? He's a 69-year-old man. What were they afraid of? His cane? I mean, it makes no sense. The violence, the senseless violence makes no sense. And that's why we're here, to try to put a stop to it, because he is the last of the three. When we look at what we have, what they didn't talk about was that how he was high on meth, paranoid, aggressive. You know, Isabel saw him. You know, she saw him shooting up in the air the first time there were shots, and then she heard more shots. And Brianna said when she saw him shoot the second time, she saw them shooting at Margarito and Benito. She saw the vehicle and she recognized the vehicle. And the guns that were in their home, they match. And there was gunshot residue on all three of them. And he's trying to make a big deal about the fact that there's more gunshot residue on one, as if that somehow means anything. He tried that same thing with Vachon, and Vachon told him that doesn't mean anything. The amount of GSR makes no difference, because the more you move around, the less there's going to be. And so how much there is 8 or 9 hours later, particularly when you've had time to wipe down the weapons. I mean, they tried to get prints from that weapon. There weren't any prints to get from that weapon. And they make a big deal about why didn't you get DNA? DNA from what? The blood? What, you want to see Angel's blood tested in his home? No one went in. There's no evidence they went into their home. Benito's blood from the car, there's no reason to test it, but that's what defense attorneys do. Whatever there is, they want more. And that's why we're here. Because what happened to Benito, what happened to a 14-year-old boy? There's a lot in the charge, and I think hopefully I've done a pretty good job of trying to explain it to you. But I think most of you know, we know what murder is, right? Thou shalt not kill is something that we know, murder. But we also need to understand that murder, you're also guilty of murder if you help someone or encourage someone, or if you're just part of a group that shoots at someone. You know, and it makes no difference which one actually killed him. They can put the gun in each other's hand. It doesn't matter if you're a party. You're in for a penny, you're in for a pound, you're guilty. And somehow the senseless violence needs to stop. Because people like Sotero Gabar shouldn't have his 14-year-old. And you heard him. I mean, you heard him, you saw him, you heard him on the 911 call, you heard the anguish. I mean, you can see what a man, how broken he is to have his 14-year-old boy killed in front of him. To have your boy die in front of you and you can't do anything about it. And even the Officer Pana, who tried to do what he can to save the boy, but he told you he knew. Gunshot wound to the head. I mean, he knew the boy wasn't going to make it. Even he was affected. Even he could feel it. And in terms of the senseless violence, you know, when you go back, they're trying to narrow down the issues. They don't deny he was there. They don't deny he fired. They're just trying to claim that he wasn't the one with the 40. They're just trying to claim some BS about self-defense. And ask yourself, a 69-year-old man, Margarito, and I'm sorry he couldn't be here. You know, not everyone survived the pandemic. But in terms of Margarito and Benito, and he's, 69 and 60, one with a cane, how are they threatening? Where is the use of unlawful deadly force against them? How can they possibly, with a straight face, claim self-defense when they're shooting through the rear of a car from two people who are trying to get away? I mean, it's just not Juan Angel Martinez who heard this particular defendant say, you have to take them out before they come back. It was also Brianna and Isabel who saw him pacing back and forth, acting kind of crazy like he was on meth. And Brianna saw him shoot. She saw him shoot down the street. And so in the end, it makes no difference who had the 40. It makes no difference who was actually the one who killed the boy or who killed Benito. In the end, if you're in for a penny, you're in for a pound. And at some point, this senseless violence has to stop. 2 of them are done. There's just 1 left. Find them guilty. Well, let's move on.
All right, ladies and gentlemen, now is the time for you to deliberate. But before I send you back, if you were taking notes, I'm going to need you to turn those notes over to Deputy Laura, because you're not allowed to use notes that you may have been taking as an individual during this trial. The court reporter is the person who's in charge of what the record says and what the record is. The other thing, I'm going to need jurors Jackson, Dwyer, Hennis, and Evans if you'll remain behind in the box. All right, so you do have the court's permission to pick your presiding juror and then begin your deliberations. If there are any questions or anything that comes up, you'll have to put that in writing to the deputy. All right, everyone, please rise. All right, everyone, please be seated. All right, you 4 were selected as alternates. You're not allowed to deliberate with the jurors unless something occurs and we need you to deliberate with them. So you are free to walk about, but again, you're not allowed to start deliberating in your head or anywhere else. You are allowed to go throughout the courthouse if you wish. I believe we're probably going to end up ordering lunch for them. So if you would like to stay around till we do that, you're more than welcome to do so. But I need you to make sure that Deputy Laura has your contact information, and you can walk throughout the courthouse if you so choose, but make sure your badges are visibly displayed. Do not do any research. If you hear anything or see somebody talking about this case, just ignore it. Okay. All right. So what we'll do is I'll have you outside, and if you have any items that you want to remove from the jury room, just let Deputy Laura know and she'll collect those. Okay. All right, everyone, please rise. And if you'll just go that way. Yes.
Oh, yeah, I know. Well, no.
I'm need you guys to take a seat while I call the doctor. All right, thank you. Defense, state.
Maybe I'll have this way over here.
All right, Brenna's gonna send, in this court, we always send the exhibits back, but she's not gonna send the weapons back. So if they want, does anyone have any objections to her not sending the weapons back? Yes. While you guys go through the list, I'll just call the docket. All right, everyone, please have a seat. Attorneys, please have a seat. I'm going to call the docket. You need to let me know if you are here. If you're not here or you don't answer the docket, I'm going to assume you're not. And a warrant may be issued for your arrest. All right. In custody, we have Adriana Ayala, Eric Johnson, Anthony Perez, Chase Gordon, Raydon Marshall, Brandon Richardson, Christopher Elan, Matthew Verhey, Jose Garcia. Oh, sorry. Ignore that. Different docket. I was moving to Friday too quickly. All right. Isaiah Martinez, that case is being reset. On bond, we have George Aguilar. George Aguilar.
Your Honor, he is here. He might have just stepped out.
All right. Marlon Simeon. Marlon Simeon. Gavino Vara. Thank you. Abelardo Torres. All right, thank you. Stephen Matthews.
He's here, Judge.
Thank you. In custody, we have Sergio Salinas. Thank you. Benjamin Castriata. I know I'm mispronouncing that name. Castrata. Someone who's a Spanish speaker, help me out.
What's that? Who's here?
Norma, can you show him the docket, please? Benjamin Andre Castruda. All right. Leroy Johnson is in custody. Malik Jason, custody.
Castruita.
All right. Elizabeth Roma. Brandy Dishner. Brandy Dishner. Matthew Salazar. Matthew Salazar. Robbie Gonzalez. Robbie Gonzalez. Robert Cuellar Lopez. Thank you. Valentine Schaefer. Denver Stewart. Thank you. In custody, we have Philippe Ibarra, Corey Hollett, Mario Tovar Hernandez. In custody, we have Daniel Granado.
Here we'll confirm.
Thank you. Krista McAuliffe. If there is a Jorge Terrazas here, your case has been closed. Abelardo Torres is in custody. Benito Garcia is in custody. John Darrenzoski.
Present with counsel, Your Honor.
And where is he?
He was in the hall last time.
All right, you need to get him here. Stephen, he needs to be here. Stephen Stokes is in custody. Paris Faris is in custody. Thank you. Mariah Lopez.
She's in custody.
All right. All right, we show her on bond. We'll see if we have her.
She was apprehended on violation of court order or something.
All right. Martin Martinez.
She's present with counsel, Your Honor.
In custody, we have Juan Carrazas, Antonio Flores, Victor Mendoza. Sharona Williams. Brianna Kelly. Betty Jean Gonzalez. Betty Jean Gonzalez. In custody, we have Rudolfo Lozano, Marco Zavala, and Ricardo Alcorn. Thank you. Thank you. Is there anyone who's present whose name was not called? Yes, what's your name? I'm sorry, what?
It's on your MCR document.
All right, thank you. Anyone else? All right, everyone, rules of the court. As you can see, we're in a jury trial. If you have a client who's in custody, Ask the deputy to bring them out. Once you request your client, please do not leave because it complicates things when you leave and your client is in the box. I try to keep the middle of the court as least congested as possible. So just take your file from the box, sit it down with the prosecutor, and they will call you in the order of appearance. Do not approach the court unless you've talked to your client. If your client is in custody and you're seeking a reset, your client needs to be out here. So do not approach the court if you have not spoken to your client and if you have not conferred with the state. All right, everyone, it's going to be a great day. Confer.
Okay, and are you're on the deadly conduct? Yeah. So, did you not end up on all the assaults? I don't know. I don't know. I got.
There's a line.
Yeah.
No, no.
On the.
Lupe, there's a line. It's in order of appearance.
Been on him for a while.
I mean, all these people are waiting. People can't cut. Hey, John, how's it going? Yes, you can.
You want him? No, I don't.
I think you guys, I just need to make sure.
Who is your client? Yes, no, he was outside in the hallway. He's here.
Okay, yeah, no, I.
Sure. No, he's here. Yeah, no. Yeah, he's here.
Yeah.
All right, thank you. Oh, yeah, it's gonna be a beautiful day if people are patient
Well, sorry.
and kind to everyone.
Okay, where's the end of this? I need to go to that one. I'm gonna go stand behind.
Good.
I'll stand behind. I'll stand behind. Oh, that one. Good morning.
Excuse me.
Yeah, yes, I guess. Yes. Yeah. Okay.
I'm not waiting. Oh, I'm next. I guess I'm. The packet has. No. He's got a low six.
Okay.
Was it clean? Squeaky clean as a whistle? Oh, it was squeaky. No.
Okay, perfect, thank you.
Hello, do you have something for me? Yes.
Yeah, I didn't know. Yeah.
Oh, just let me see. Okay, so, all right, you're welcome.
Waiting, testing to be completed. Possible check JD.
It's all true and correct within your
Okay.
personal.
And just so you know, because I just found out, it's for oil field work, so it's 2 weeks on in Midland and 1 week at home. So I don't, she's not in Midland, is she? I mean, no. And I was told by Judge Skinner, technically GPS can be monitored anywhere.
Just play that game every year. Remember that?
All right,
Oh, yeah, no,
if people, excuse me, the people who are waiting to see me because your file has been turned in, if you could have a seat, because I'm trying to keep this area as least congested as possible, you'll be called in the order in which I received your file. So who's here on Stephen Matthews? All right, and where's your client?
Back for Stephen, come on up.
Oh, and step back. Yes, thank you. Thank you. All right, what is happening with this case?
We had reset it for mental health evaluation. We've gotten that accomplished. We should have a written report sometime within the next week.
Yes.
That's short. Involved.
All right, and state, have you had a chance to speak with the complainant?
No, Your Honor, not yet.
All right, so the state's been waiting to speak with the complainant since September, according to the docket I have.
I understand.
Okay. All right, Ms. Ferguson, on Mr. Matthews, can I have a date for the second week in January? We'll come back then and you all should have made a decision by then on where this is headed.
January 12th.
All right, so Ms. Ferguson will give you a reset form for January 12th and it'll be at 9 a.m. Yes, after you sign the reset form. Who's here? Mariah Lopez. And where's Mariah Lopez?
Judge, she was arrested on a misdemeanor case, and so she is in jail. Just remember that, arrested.
State, sorry, state. I'm Mariah Lopez. Are you aware that she's in custody?
No, Judge, I didn't do that, but we could.
Okay. All right, Norma, do you know if Miss Mariah Lopez was brought over from the jail?
She was not, Judge, we do not know she was in jail.
All right, recall this for next week. What date?
I can do this. No, I can do the 15th.
All right, so we're going to come back on December 15th. And my understanding that there was some discovery issues, social media discovery. Have you received that, counsel? Yes, that's what it says. We were back here on October 20th, discovery social media.
Oh, yes, I have not received that yet.
All right, state defense hasn't received the discovery of the social media on Miss Lopez. We're going to come back on December 15th to see where we are.
Yes.
All right, thank you. Your excuse.
Okay.
Who's here? I'm Valentine Schaefer. Mr. Schaefer, come forward.
Yes, yes, yes.
All right, where are we on the PTD? We were here for that last time. Has he filled out all the paperwork?
Yeah. Waiting for the interview.
All right, Ms. Ferguson, I need a reset date for PTD on Schaefer. All right, Ms. Ferguson, we'll give you a reset form. Make sure you follow through on all those conditions, okay? And we'll see you back on February 2nd.
Okay.
All right, you need to reset.
Just kidding.
All right, who's the attorney on Ricardo L? Yes. Have you-
State needed to see whatever that history packet is. I just need to provide that to the state.
Thank you.
You're welcome. All right, Martin Martinez. Good morning. Have you received an offer from the state?
I have not, Your Honor.
Why not?
I should go to the state, they informed me that there's like 7 victims that they need to talk with, their advocate is out, and so they need some additional time to confer with.
Judge, there are a lot of complaints here in this case. We have had a good time.
And I will let the court know, we did receive the discovery, we're still going through that, it's quite voluminous.
All right, so this is deadly conduct firing into a building. So you're saying there are a lot of people in the building?
Yes, Your Honor, there were 7 people. Originally, there were 7 cases that were going to be indicted, but it appears that there were one. All rolled into 7 people.
All right, so this is the last setting I will give for the state to give the discovery to defense and make an offer because this has been going on since October. All right, Ms. Ferguson, I need a January date on Martinez for discovery. 3rd week. All right, Ms. Ferguson, we'll give you a reset form. We will be back there at that time and state on that day, you need to make an offer to the defense.
Yes, sir.
You're welcome.
Zuka. There's 2 more I marked on that sheet.
Who's here on Victor Mendoza? All right, is your client in custody or on bond? All right, did you ask for him to be brought out? Where is he?
They're still in line.
All right, as soon as he comes out, we'll take that up. Thank you. Who's here on Denver Stewart?
Stewart.
All right. So I have the motion to amend conditions of bond. And also, I guess this is recently indicted.
Correct. That's
Okay, so with regards to the GPS, have you had a chance to review the motion to amend GPS conditions?
Yes, Judge.
And are you going to be in objection?
I'm not an objection to partial just for purposes of working. That's what we're asking for, Your Honor.
Okay.
Now, just so we're all honest with the court and don't provide the information. Trial services. He does work for the appeal, which is scheduled for the 2 weeks on, 2 weeks off. The 2 weeks on, it'll be in Midland where it's going to be living with his boss. We'll be able to provide all of that information to monitoring.
Okay. All right, so here's the issue, and I'm trying to make sure I work this appropriately. Because if you do GPS for work only, they're gonna expect him to go there and work and then come back home. So the way it's been worded by the defense is GPS requirement is amended to GPS tracking to allow for employment. Are you okay with that wording? And I'll put in here, it's to be upon proof of employment, work schedule, and location. So you'll have to provide where you're going to be working. You have to provide the work schedule to them. And you're going to need to provide where you'll be staying if you're going to be working, not in Bear County, but somewhere else. Do you understand?
No.
All right, if there's some issue, counsel, with GPS, with these instructions, because sometimes they have issues, then I'll have GPS zoom in and we can take care of it that way.
Thank you, Your Honor. And then for reset.
Yes, Ms. Ferguson, can I have this recalled in January, please? 30 days.
Thank you.
You're welcome. All right, we're going to come back on January 19th. Just get your client to sign the reset form. Thank you.
Okay.
Who's here on Sergio Salinas?
I am, Your Honor.
Where's your client?
He's in custody. I request.
Has it been brought out? All right, once he's brought out, I'll take it up. Robbie Gonzalez,
Gonzalez, come here.
where's your attorney?
I'm here, Judge.
Take your hat off in the courtroom.
All right, what is the status of the psychological?
We are still waiting on the examination. Our expert is going to be examining between the first and third hour.
Of this month?
Yes.
All right, Ms. Fergus, can you recall Gonzalez for January, please? Late January. All right, Ms. Ferguson will give you a reset form for January 31st at 9 a.m.
Very much. Oh, Your Honor, I'm gonna be out of country.
Oh, where will you be?
Don't leave the courtroom.
That's wrong.
Okay, how long are you going to be there?
I think I'm on the 5th of February.
All right, Ms. Ferguson, can you put this the second week in February? You're going to need to confer with the state off docket. All right, we'll be back on February 9th. You're welcome. Just have your client sign the reset form and then you're excused.
I had him. It's in the back row.
Here you go. Who is here on Abelardo Torres?
We are, Your Honor.
And is your client in custody?
He is, Your Honor.
Is he out here?
He's out here.
All right, come on up.
Otis, thank you, Your Honor.
You're welcome. I believe your client, the last I had is that he's awaiting transfer. Is that correct? With the competency?
So I'm getting. I saw one report. Incompetent, but.
All right, Ms. Ferguson, can you check the system on Abelardo to see if restoration has occurred? Because I show as of, well, in July, we were waiting transfer. Counsel, do you know if the restoration has occurred and there's been a hearing? Yes. Thank you. All right. Ah, thank you. That clears it up. The only thing I need to do is to make sure that y'all actually had a hearing that says his competency was restored. But council has just shown me a document that competency has been restored. So where are we with regards to discovery on this case?
Judge Mr. Adams is on the case.
Mhm.
Other two in these cases.
And I know you've been recently appointed.
Yeah, they're factually complicated, Judge. I haven't started going through them, but does involve ballistics. That nature, Judge. It appears I have everything that I'm entitled to, but I would ask to be able to come back to support it if I notice there's something.
All right. Is late January enough time for you?
I think absolutely, given how long he's been in custody. I think that should be plenty of time.
Your Honor, so he's gonna take over all three cases. I'm gonna be.
Are you asking to be relieved?
Yes, Your Honor.
All right, which case are you on?
I'm on the least offensive. I'm on the, let's see. The deadly conduct firearm,
Okay.
it's a third degree.
All right, do you have any objection to Mr. Adams withdrawing?
Yes.
All right,
I
so,
guess I'll stay on.
all right, so he's going to stay on, so you'll have two attorneys. Ms. Ferguson, I need a date in late January for this. All right, thank you. Okay. Okay, thank you. All right, we're gonna recall this for January 31st. And that will be a regular reset, but you all are gonna have to confer off docket with the state about offers, and then we'll see where we are on January 31st. All right, thank you. Who's here on Victor Mendoza? Oh, is your client brought out yet? All right, just give us a moment. What is it?
Super easy one. May I approach the VIP?
Yes. All right, Mr. Aguilar, come forward.
With the politics?
Okay. When you're drug tested today, what are the results going to be? And you are getting drug tested today.
We've already done that.
You anticipated.
It's so negative.
It's like we knew how the honorable court liked.
Okay. Right. You need to make sure that you stay clean and sober. If there's an issue with your sobriety or you see yourself about to fall off, you need to go to a class or speak to someone or call probation. You understand? All right. Good luck to you. Probation. I've signed everything.
Thank you.
You're welcome. Do we have the immigration, I'm sorry, the interpreter here on Daniel Granados?
She's still gonna.
Yes, I am going to want the interpreter.
We'll wait for it.
All right, just request them to get them. Sergio Salinas?
But you don't.
No. we- Who's here on Sergio Salinas? Is your client in custody?
Yes, he has a question.
Is he here?
Yes,
All right, come up. Have you conferred with the state?
I have your honor.
What is happening with this case?
Judge, the defendant has an ad robbery as the leading identity is filed at large. Right in the middle. With one of the attorneys who has passed away. I'm trying to figure out what was happening with that one.
All right, Ms. Fergus, can you recall Mr. Salinas for the end of January? All right, we're going to come back on January 30th and we'll see what is up with any other cases that are alleged to be pending, okay? Brenda, are you ready to go on the record?
Oh, no.
All right, I'm gonna need everybody quiet in the box. Who is here on Rodolfo Lozano?
That's me, Judge, we're ready.
All right, if you could have your client come up. Court is calling 2018 CR 5872, State of Texas versus Rodolfo Lozano. Can I have parties announced for the record for the state? Defense?
Andrew Fred.
Are you Rodolfo Lozano? Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review it with your attorney? Did you understand it?
What's wrong?
Are you the same Rodolfo Lozano who was placed on deferred adjudication in 2018 CR 5872 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on January 14th, 2020 for a term of 4 years? Is that you?
Yes, Your Honor.
State?
Violating condition number 5 in Bear County, Texas, the defendant Adolfo Lozano has been in there, failed to report to the supervision officer as directed for the months of October 2021 through December 2021 in violation of condition number 5
How do you plead to that? True or not true?
True, Your Honor.
with all the violations.
Any objections to the state's waivers?
No objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there an agreement?
No, Judge, the state has a recommendation
State, what are you requesting?
for requesting that you deny the NPR and alter and amend to follow probation's recommendation, which is to include state ISF, the dual track, 200 hours of community service, and report weekly to the register for IOP.
Defense, what are you requesting?
Judge, we're requesting to be continued on probation and allow the transfer to Nueces County.
All right, so why wasn't he reporting?
Mr. Lozano would like to address the court. Hold on.
Yes. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Dr. Lozano,
Yes. Why were you not reporting?
I did report to Nueces County in December. I was asked a series of questions, and one of the last questions she asked me was, I plan on moving back to Perry County in 6 months, which I plan on moving at the end of the school year. And that's one.
Well, I mean, that doesn't explain the not reporting to me, and I don't see anywhere where I gave you permission to transfer to Nueces County.
That's part of my understanding was he was transferred. Now, the NCR says the Hidalgo County, but we believe that was Nueces County who was allowed to transfer to. I'm not sure about the court's ordering him to, but I believe probation was trying to work that out. This time, Judge, we want to point out to my client, he's a single parent after losing his wife to cancer. And so we ask if he would be allowed to continue.
When is this alleged to have happened?
2 years ago.
So being a single parent, He was trying to transfer down to Oasis County because that's where his son is currently in school. So at the end of the school year, he was going to bring his son back to their county. Finish his probation here. So when Oasis County said, hey, how long are you planning to stay? And he goes, oh, just a few months. Until the end of the school year, they didn't accept his transfer. So what we're asking, Judge, is for him to be allowed to continue his probation. We've not put an agreement with the state. The agreement with the state is basically not to revoke, but continuing this probation.
Who's your child living with? No. He's not at the Bear County Jail. Who's your child living with?
You and my sister.
All right, and where does your sister live? All right, and when your wife was alive, your child was living with your wife?
With me and my wife.
And where were you living at that time with your wife 2 years ago?
We were living in Revocation County.
All right, I need you all to be quiet in the box. We're on the record.
Repeat your last.
Repeat your last answer.
Texas. Broward County and Wilson County.
I will tell you, here's my issue. My issue is this is the second time you've appeared before me for not reporting. That's a problem. So that means you know you're supposed to report and you're not doing it. So what is up? What's happening with your father?
My father.
Yeah.
Working.
How's your relationship with him?
And was talking about that. It's better now.
No, but when you were out, were you not with him? And then you wanted to leave because you were having complications with your father.
Yes, ma'am. I'm no longer living with my father. I don't want to take care of my son.
Is there anything else?
Judge, we wanted to, he's been in custody since October 23rd. He's signed up and working on his Padre and Compadre class, his parenting class. One of the violations listed as he has successfully completed his parenting class, but he did sign up to that parenting jail. It's currently.
When was he taken into custody? Because I see that this motion to revoke has been pending since January 2022. How were you picked up?
My understanding, Judge, he was picked up.
No, I'm asking him.
I got picked up in Oasis County,
All right, when?
October 23rd.
Okay. All right, anything else from either side? All right, the court is going to deny the motion, alternate amending conditions to include ISF. And there's to be IOP and UA hotline upon release. And I'm going to want field visits. I already requested that field visits be 2 times per month. So we're going to go with field visits 2 times a month, and probation. If there is a, if you would like to have one of his reportings count for the field contact, you can do that if you so choose. And Mr. Lozano, that's the court ruling, or if you would like, if you no longer want to be in probation, I'll sentence you to 3 years. All right. Is there anything else from either side?
Your Honor, may I have just clarification, the state ISF, do you want that dual tracks? Or
We're just going to do cognitive with that. What is the wait time for cognitive?
let me check. About 33 days.
All right, we're going to just do cognitive.
And after release, he is to still reside in Bear County, correct?
Yes. And you are not allowed to leave Bear County without the court's permission. So if you want to go somewhere else, you need to have a plan for who you're staying with, and you're going to be staying by yourself. You're not going to be allowed to live with other adults where you have complications with them, and then you fall by the wayside on your probation. You understand?
I don't want this.
All right. All right. Is there anything else? All right. Thank you. Who's here on John Derazowski?
I am, Your Honor. Mr. Derazowski is now present in the courtroom. He came at 9 o'clock.
All right, have him come forward.
Return, Judge.
All right, today is his plea deadline date. What's happening?
Judge gave the offer. Today.
No. We were here on November 9th. An offer was tendered, and we're coming back to here today because the day is the plea deadline date.
Governor had to.
All right, do you need time to think about the state's offer? All right, Ms. Ferguson, on this case, recall it for the last day we're gonna be here for this year. All right, we'll see you back on the 19th. On the 19th, you need to let the court know whether or not you're accepting the state's offer.
Thanks, Judge.
All right, you're welcome. They're gonna give you a reset form. All right, who's here on Robert Cuellar? All right, if you have your client come forward. And where are we on the PTD?
He has signed his application and wanted to know that it's in the process.
All right. Ms. Ferguson, I need a PTD date on Cuellar. All right, Ms. Ferguson will give you a reset form and then you are excused for February 2nd. Thank you.
Have a good day.
All right, you too. Davina Vara. Is your attorney here?
Yes, Judge.
All right, thank you. Yes. And Mr. Kuntz, I'm aware that I believe you're in jury trial.
I am in this very court.
And I noticed that you were fairly recently appointed for this to be a murder case. So where are you? Do you know where you are with regards to discovery?
I don't, Judge, and part of the problem is there's no first hearing for a more in this case, and so. So my client and I haven't even had an opportunity to go through the discovery ourselves together. So I would obviously request a reset for at least 30 days or 60 days so that you can give us a little bit of time to get up to speed.
All right, Ms. Ferguson on Gavar, can you put this for the end of January, please?
I think it's February 2nd. February 2nd.
All right, we'll be back on February 2nd.
You're gonna ask, he's been on a leg monitor continuously. It's my understanding without violation since March of last year, March of 21, on 2 years. We're requesting that you take him off the leg monitor if possible. If you are unable to take it off altogether, if it can just be tracking.
All right, if you will file a motion and see if,
The state cannot agree, we discussed it.
oh, no, I mean, so that a first chair can come down here and argue it, or either Marcus can argue it,
Sure.
but just ask Ms. Ferguson to put it on the docket. We can put it on the docket before our last case.
Okay.
All right,
Okay.
so you're
Is he
welcome,
excused?
after he signs the reset form.
Great. Thank you. Thank you.
All right, who's here on Paris Farris? All right, and where's Paris Farris? Come forward. All right, where are we on this case?
Judge, the evading is a first or second setting. He has a burglary of habitation, which was just indicted yesterday. And so the state needs a little bit more time to wrap both up together and talk to their complaint witness.
All right, Ms. Ferguson, can you recall Mr. Farris for January, please? Third week in January, Paris Farris.
I think the 19th.
All right, we'll come back on the 19th, Mr. Farris, and see where we are with the discovery, okay? Who's here on Victor Mendoza? All right, hi. All right, you're actually next in line, so I'll take you up right after I do this. All right, Victor Mendoza, what is happening with this case? I see that an offer was tendered and today is the plea deadline date.
Judge, this is Leo Gonzalez. He's actually asking here on his behalf. He's in Gillespie County. He's asking if the case can be recalled for tomorrow.
All right, Ms. Ferguson, are we able to recall this for tomorrow? Yes. Let me ask you, are we able to do it by Zoom then, or no? Or if we can call him next week? All right, what date? All right, yes.
May I check the schedule,
Yes.
just so I don't want to create a conflict?
All right.
I was trying to look at it before.
Mr. Mendoza, we're limited to the number of inmates that we're allowed to bring over due to safety issues and also capacity. So we're not going to be able to see you tomorrow, so it's going to have to be next week, okay? But we'll try to get your date as quickly as possible.
I think you can do that, Judge. If not, I'll have to contact the court later today and.
All right, Ms. Ferguson, what date? Just 1 second.
Okay, hold on.
What date? All right, we're going to bring you back on December 13th.
13.
Thank you, Judge.
You're welcome. All right, can I see the parties on Daniel Granados?
You stay there.
All right, so we are not on the record, but where are we on his case, please?
Judge, last time we, that we could contract with starting the victim in this case.
Yes.
We've since requested, to run our investigator, and then kind of better number for them. We got one number back, for their dad, so we're still trying to have contact with the actual victims, through their father. So if we have one more reset, just need to send contact them.
All right,
I would request something short, not something like next year, maybe a couple of weeks.
okay. And where are we with regards to his immigration letter? Has that?
We have the immigration letter and I have that available.
All right, state. It would either have to be the 19th or the 20th.
Okay, that's fine. I plan on continuing to contact them this week and hopefully have something good. Thanks.
All right, Ms. Ferguson, you have this one, just this one called on the 20th?
Could we do it on the 19th?
Yes, okay.
Yes.
All right.
Sorry, but I can't have you know,
All right, no problem. So we'll be back on the 19th at 9 a.m. Do you have any questions, Mr. Granados? No. All right, thank you. And if you could remain, we have another interpreter. Yes, Your Honor. Thank you. On this side. Who's here? Antonio Flores? Oh. All right, so Mr. Flores, come up. All right. So on this case, where are we with the immigration?
Judge, we were here on the 31st of October.
Yes.
You gave the number for Bobby Gebbia. I contacted him. He said that they would have time. Apparently, he has not been interviewed.
Norma, can you call, he hasn't been interviewed for the immigration. Do you still wish to go through that route, or do you want us to just appoint an immigration attorney?
Judge, if we want to support the immigration attorney, it might be.
If we can appoint an immigration attorney on Mr. Flores, please. All right, and they will give you the number, counsel, so you can give it to your client.
Unfortunately, the state has made an offer work to try to accept it, but we need to get to the plan before you can do that.
Does he have time to wait? I can probably do the public defender's office.
Yeah.
All right, see if they'll come down. Okay. All right, if you'll just have a seat, we'll see if we can get the immigration attorney here. Hi. How are you doing? Oh, it's great. It's busy, right? All right, you too. It's always awesome seeing you. I love when the interpreters come.
Oh, thank you.
All right. Yes.
You want me to finish writing these?
All right, so Norma, on this, let me give this to you.
Okay.
Who's here on Corey Hollett? All right, is your client here? Ah. Is he on bond?
Yes.
All right, could I have a prosecutor, please? Court is calling 2022 CR 7189 and 2022 CR 8662, State of Texas versus Corey Hollett. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the-
Jonathan Ross for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 12:07 p.m. Counsel, have you had any contact with your client?
Sure.
All right, and the court will note for the record that the defendant is not present. Have you made attempts to contact your client?
Yeah.
All right, Deputy, was a Corey Hollett in the hallway?
No, Your Honor, sorry.
State?
Your Honor, the state moves to tackle events on before. I want the issue for incidents.
That'll be granted. Your client will be remanded without bond as well. If you get in touch with your client and he makes an appearance, the court will reconsider.
Thank you.
All right, thank you. Oh, I gave it, I read it, I gave it to Norma. It's about a defendant in court. Are they still here in court? All right, if you have them come up. Hello. Oh, great. It's always nice to see the military. Thank you for your service.
Yes.
All right, so I've received your letter. What I'm gonna have to do is I'm gonna have the coordinator see if he can reach your fiance's attorney. And then your fiance is in custody, correct?
Yes, ma'am.
I'm sorry, where?
And water.
Waller County.
Yes.
Okay. So what we're gonna do is I'm gonna get the information, and if you'll remain in court, I'm gonna see if maybe we can set up a date to have him zoomed in here from Waller County. All right, so we'll probably be able to take care of his matter through Zoom, because it's difficult for us to get a person transferred here if they have a hold in another county. So we can do it that way.
Well, you know, he had the line,
Mhm.
you know, water line, and I drove out there to go run. Well, like, they raised it, like, maybe I should just come down.
All right, just give us a moment. We're gonna see if we can, because where did you drive from?
I'm here and said, I'm stationed on Fort Santa, but when I do it for one time, it's like 2 hours and 18 minutes.
All right, if you'll just be patient with us, we're very busy today. What we're gonna do is we're gonna see if we can get in touch with whomever his defense attorney is and get him to come to court today to speak with you, okay?
Thank you.
All right, thank you. Who's here on Juan Carranza?
I am just,
All right, if you can come forward. I think you're in trial with us.
I believe so. This
Yes.
is Eric Reynolds' client. He's stuck out of county, so I'm checking on his behalf.
Okay.
Carranza, right there.
All right, so we need to get the DNA comparison update. Do you have information on that?
This morning and don't have it in yet. I think since the last setting, we did get the same and the forensic interview, so if they wanna, there's no adding if they're aware of it, but the DNA we still don't know.
All right, on Carranza, Norma, can I have a date in late January for discovery?
February 2nd.
All right, we're gonna come back on February 2nd. That'll give a chance for your attorney to be here and hopefully the state will have the DNA comparison, okay? All right, thank you. Norma, that letter I gave you, can you see who that attorney is for him and see if that attorney can come to court today? That is Carranza. Who's here? I'm Brandy Dishner.
I am good.
Yes, where's your client?
I don't know.
All right, is she on bond?
I think she is.
All right, is this still a warrant out for her? Because I see here from the it is 2022 CR 2992. This case was transferred from another court.
Yeah, no, that's a reason for me too, not, I don't have another case for 379, it's unindicted still.
All right.
But yeah, I checked the bailiff, they said they didn't bring her over, whatever.
No. I'm trying to see if she has a warrant. She doesn't have any warrant. All right. Have you made attempts to try to get in touch with her?
I have that.
All right. Can I have a prosecutor? Court is calling 2022 CR 2992 State of Texas versus Brandy Dishner. Can I have parties announced for the record for the state? Defense?
Marshall B. White.
All right, this hearing was scheduled at 9 a.m. It is now 12:13 p.m. The defendant is not present. Defense, have you had any contact with your client?
No, I have not.
Have you attempted to contact her?
I have not.
All right, deputy, was Brandy Dishner called in the hallway?
Yes, she was.
All right, state. That'll be granted. Your client will be remanded without bond. If you make contact with her and she makes an appearance, the court will reconsider.
Okay, thank you.
All right, thank you.
You would have had a lot too.
Who's here? I'm Benjamin Castruccia. All right, thank you. All right, Mr. Schaefer, the immigration attorney will be here in 20 minutes. All right, where is your client?
Judge, he is actually at home. I finally got a hold. He's been calling the office. And I've been tied up back and forth.
All right, I'm going to recall this for tomorrow. He needs to appear. If he doesn't appear, a warrant will be issued.
He'll be here, Judge, and we're going to dispose of his case.
All right, Ms. Ferguson, his client is being recalled for tomorrow.
Thank you.
You're welcome. All right, thank you. Sarah Marco Zavala. Can I have someone from the state and probation? This is no application. Court is calling 2022 CR 10023, State of Texas versus Marco Zavala. Can I have parties announced for the record for the state? Defense. And are you Mr. Zavala? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Zavala, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
I believe so.
Okay, let me check. It appears you are. Mrs. Zavala, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days to 2 years in the state jail facility. I'm going to need y'all to be quiet in the box. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Before we continue, counsel for state and defense, it appears that the judgment and the indictment 2016 CR 4303W, there should not be a W on that in the indictment. So is there any motions to amend?
Yes, Judge. Is it just like, is it just typos?
I don't know. So in the judgment, for the evidence that's being presented to the court, it's 2016 CR 4303. And the indictment is listed as 2016 CR 4303W. Sure.
Yes, Judge, we would move to strike the W from the indictment.
All right, Mr. Zavala, did you understand removing the W from the indictment? That's a substantive change to the indictment. All right, did you understand that your attorney has 10 days to prepare for trial? Are you giving up those rights and are you wishing to continue forward with this plea bargain agreement? All right, counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent, was legally sane at the time of the offense? Mr. Zavala, has anyone threatened you? Zavala, has anyone threatened you, coerced you, or placed you in fear? Thank you, to enter this plea. Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility and there are no applications. Did you understand that to be the plea? Defense? State?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge, state exhibit 1.
Mr. Zavala, I just want to add things to that name. I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
The school would ask the court to follow the bargaining agreement.
All right. Court will follow your agreement, sentence you to 6 months in the state jail facility and give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. How old are you?
42.
All right, you're 42. You have decisions to make. And your decision that you need to make is, do you want to spend the rest of your life in and out of jails, in and out of prisons? And you're getting to the point with these theft cases that you're going to soon be looking at habitual status, which means that your range of punishment may be from 2 to 20 years. Being a thief or theft as an occupation, I know it's glamorized sometimes in movies like Ocean's 11 or It Takes a Thief. And I know when I'm saying It Takes a Thief, I'm aging myself. You probably don't know what that is, but theft is not an occupation. If you want something, go get a job, right? And if it's not worth you having a job to get it, then it's probably not worth having. You understand? All right, you're gonna have to do better. Otherwise, you're gonna keep coming back and forth. All right, good luck to you. Thank you. Who's here on Malik Jason? And where's your client? All right, come forward. All right, so I noticed this is the first, it's setting on the indictment. Where are we on discovery?
We've completed that. The state made an offer. We're contemplating a counter offer. We're not quite ready. We also think we might hire another attorney. Possibly promises to keep the offer open for a while. We're still conferring.
All right, Ms. Ferguson, can you set this in January and that will be your plea deadline date?
The 30th.
All right, so we'll be back on January 30th. At that time, you need to let the court know whether or not you're accepting the state's plea offer. Do you understand? All right, and if you choose to hire an attorney, which of course is your choice, you need to let them know that your plea deadline date is January 30th, okay? All right, thank you.
Thank you.
You're welcome. Brenda, I mean, it's odd if Mr. Callahan is not here in trial.
We haven't had him in trial in a while.
Yeah. All right, who's here on Christine McAfee? I'm sorry, McAuliffe. Brenda, for some reason, my vision is off today. I'm just making up names as I go. All right, today is plea deadline date. What are we doing?
We are gonna go through the paperwork.
All right, Ms. Ferguson, can I have a PTD date on McAuliffe?
February 2nd.
All right, you're gonna come back on February 2nd. That paperwork needs to be turned in. If that paperwork is not turned in before February 2nd, you're gonna be back here on February 2nd for a jury trial. Do you understand? All right, thank you, Ms. Ferguson. We'll give you a reset form. Thank you. All right, who's here on Elizabeth Romo? And where is Romo? Come forward. All right, where are we on this case?
Discovery is complete. The state made an offer. We made a counter offer. We were getting closer. We're still conferring.
All right. We'll put this on the same date as your other case. And that was January 30th. Ms. Ferguson, if you can have Ms. Romo come back on January 30th, that will be a plea deadline date. All right, we'll see you back on the 30th. They'll give you a reset form. You're welcome. All right, who's here on Stephen Stokes? All right, Mr. Stokes. All right, we're here for discovery.
Yes, the state has received.
Man, don't leave the courtroom.
State has received the autopsy report, but they're missing a few items of discovery, Judge, 911 calls. And in addition, I've asked the states to find out where the complainant was born. And I think it's relevant to the case. We don't have that information. So
All right, is that easily solved with a birth
hopefully
certificate?
from the complainants, they don't have the birth certificate. So I guess that would do it.
Oh, well, I don't know I'm sorry,
Yeah, sure.
I don't know the age, so I don't. Okay. Well, and I'm assuming, are there CPS records?
Yes.
Yes.
All right, so the date of the child should be in the CPS records, and the CPS should have a copy of the birth certificate.
Okay.
From my practicing in CPS court.
We're seeing a lot, but okay.
All right, so where are we on CPS records?
They have them. They're in the file.
All right, so do you have those?
Can I file a protective order?
Yes.
I'll file that today.
And is it the complete CPS records?
I believe so, Judge.
Right, because I'm assuming that it's at least over 20 pages. Okay. All right, and is this case going to stay as an endangering of a child case, or is it going to be something else?
Judge, I think that they just got the autopsy back. I think within the last 2 weeks, and I don't think that decision has been made yet. I
Can we get a recall for a week? So we kind of know where we're going.
We're going to recall it in January. Or either the beginning of February, because definitely by the beginning of the February, all the discovery should be turned over. And if something's going to be refiled or re-indicted as something else, it should be done by that point. All right, Ms. Ferguson, on Stokes, can we have this recalled for February?
Judge, I'm gonna file a bond reduction and I'll approach Norma to see if I can get it set before.
Yes.
We can do February 9th.
All right, we're going to come back on February 9th. So this is what the court is expecting on February 9th, for you to have already filed the protective order. Usually the state will have a copy of that.
I'll file it right now.
All right, and then the 911 calls. State, make sure that you have the 911 calls for him. All right, we'll come back on February 9th. Is there anything else?
That's it.
All right, thank you. Brenda, do you see what page Mr. Stokes is on?
Yes, page 7.
All right, thank you. All right, and we're still waiting for the immigration attorney on Flores.
That's.
All right, thank you. All right, thank you. Hello. Hi, bye-bye. Have a great one. All right, is Gregory Retron, is that criminal trial division or family violence?
CTD.
All right,
Is it the motion, Judge?
yes.
He called me before.
So you have no objection? Okay. And if you can let him know, counsel, that they've been granted, and we'll set it sometime in February, if he's okay with February or either March.
Okay, Judge.
Norma, on this. I'm Brian, I'm looking up to for continuance. Can you set up and mark whenever we presiding? Someone wants to know the presiding. But if you have, we're presiding in March, then set it sometime in March. But if you're later than March, then set it later in March. You said this down. Yes. Thanks. And if you could let Mr. Rittenhour know that we don't have a date yet, but tell him it'll be after. Yeah, so that he can take care of his one. Thank you. Hello. I'll make a note of it. All right, thanks.
Can I talk to you?
Sure. What is? Oh, it's here? Oh, well, we may need to take our little break. Yes, we can. All right, everyone, we're gonna take probably just one second. Everyone, we're gonna take a break because Brenda hasn't had a break. And I don't want to be accused of violating labor laws, not only for her, but for myself. So I know everybody wants to get things done and they want to get things done quickly, and I appreciate that. But we've actually been here before 8 in the morning and we haven't had a break. And Brenda had to type in me reading a 36-page jury charge. So we're going to take a short break. Everyone be patient. We're going to try to get to all of your cases today, but I think it's best that everyone get a chance to take their break, especially before my mom calls and accuses me of being unfair to everybody. So I don't want that. So we're going to take a break. We're going to be back here at 1 p.m. everyone. Yes, you can mute us. All right, so let's reset this and have Mr. Hardy here. And see if you can put, that defendant is in Waller County. So is there any way to see if we can have a Zoom set up for him from Waller County? Okay, so it's in Waller. Waller County is in Waller, outside Houston. You know, we need to put a map of Texas up so we can, yes. So it's in Waller County, outside of Houston. All right, so probation. What is, can I see the file on Lozano, please? It was filed away, if I can have it back. Rodolfo Lozano. And Mr. Schaefer, if deputy, if you could let him move the immigration attorney, please. And Mr. Lozano, if you could come back.
You need him?
Yes, Lozano. Brenda, it feels like a Friday, but it's not Friday. All right, so we're back on the record in 2018 CR 5872, State of Texas versus Rodolfo Lozano. Could our parties announce for the record for the state defense? If you could announce.
Andrew Fraley for the defense.
All right, and you're Mr. Lozano?
Yes, ma'am.
All right, you're still under oath. My understanding is that you had a conversation with probation. Is that correct?
Yes, ma'am.
All right, is there something you needed to tell the court?
As far as just the situation. with my son.
Yes, your living arrangements.
Well, I have my own place in Corpus Christi right now, and my son lives with my sister. He's currently with my sister, and she has MS right now. That's also recently lost my mother as well, so there's no one else to take care of my son besides me.
And how old is your son?
He's 14.
All right. So who's going to be staying with you in Corpus Christi if I were allowed you to be transferred to Corpus
I have my
Christi?
own trailer, ma'am. I have a mobile home that I live in.
All right, no, I mean, do you have anyone around to help you and make sure that you remain on track, some sort of support system?
I mean, just my father and my sister. That's it. That's all I got. That's my sons.
All right, this is what the court is going to do. The court is going to rescind its previous order of ISF. Any objections, state or
Definitely no objections from us, Your Honor.
All right, so this is what I'm going to do. I'm going to deny the motion, alternate amend conditions. You're still going to have to do intensive outpatient treatment. How long will it take for him to do a TAP evaluation?
I get it done within maybe a week and a half, Your Honor.
So here's the thing, I'm going to trust you with the TAP evaluation out of custody. If you don't report for that TAP evaluation, then what happens next is all on you, because I'm a firm believer that there are consequences for actions. You understand?
Yes, ma'am.
If you ever come before me again from not reporting, there are going to be consequences for actions. Now, I can tell you the only reason why I'm changing my mind on this is because, one, this is the first I'm hearing about it, right? Because no one told me this before, and I don't think probation or the state knew before. And two, honestly, it's me doing it because I realize that your sister probably needs help. So I'm not doing this because of something that you have done that makes you worthy of it. You understand?
I understand, Your Honor.
So we're not going to be here again with you being, violating rules. I'm not going to see you back here again for not reporting because you know you need to report. Do you understand?
I understand completely, Your Honor.
And there's no excuses for not reporting. Do you understand?
Yes, ma'am.
And do you understand that with this case, you're looking at 2 to 20 years in prison if you are unsuccessful and if you're revoked? You understand?
I do understand.
And so you say your son is 14. If you end up going to prison for 20 years, he'll probably be in his 30s when you get out potentially with children of his own.
So I'm trying to avoid.
All right, you're gonna have to do better.
Yes, ma'am.
All right, so we'll do TAP outside of custody. If he does not make his TAP appointment, file a motion to revoke. So that'll be TAP evaluation and whatever TAP recommends. If they recommend outpatient treatment, if they recommend inpatient treatment, we're going to start with intensive outpatient treatment first. I'm going to want the UA hotline for 6 months. We'll see how that goes. If it's going well, then we can slowly start tapering that off. But I don't want UA hotline for 6 months and then no UA hotline. And he needs to be tested at least once a week. I'm going to want the field visits 2 times per month. And I'm going to do a transfer. What is the county in Corpus Christi? Okay, transfer to Nueces County. Is there anything else?
No, Your Honor.
There you go.
Your Honor, may I ask that we do weekly Zoom reporting until his transfer?
All right, there's going to be weekly Zoom reporting until transfer. So your probation will explain to you about that, but you need to make sure you report. If you miss one-time reporting, the only excuse you may have for not reporting by Zoom is if there's a hurricane and the power lines went down. And even if the power lines went down and you don't have any Wi-Fi, you better get on a bus, get on a plane, get on a train and try to get to probation and report. You understand?
Understand.
Or either come to court and say, I'm here because, as you know, Judge, there was a hurricane and I don't have any Wi-Fi. But otherwise, you better report.
I understand, Your Honor.
We're not going to be here for this again.
No, ma'am.
Anything else?
No, Your Honor.
There you go.
All right, thank you.
Thank you.
Who's here on Brianna Elizabeth Kelly? All right, if you all can come forward. And probation, this is for regular probation.
Yes.
Court is calling 2022 CR 11569W, State of Texas versus Brianna Elizabeth Kelly. Could I have parties announced for the record?
Marcus Sanders.
Dancing Preview representing Ms. Kelly for Sean Brown's office.
All right. And are you Miss Kelly?
Yes, ma'am.
Right, what does your T-shirt say?
Mud hens.
Mud what?
Hens.
Oh, mud hens. Okay. All right, counsel. I'm going to show you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. I'm always interested when I see T-shirts because I'm wondering where they come from, which
Sounds like
state.
the name of a team.
Yes, is that the name of a team?
I got it from the thrift store.
Okay. No, I like it because at first I thought it was maybe related to mud bugs, which is Louisiana fair. So Brenda, that's what I was thinking. All right, I'm going to show you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did
Yes,
you
ma'am.
understand it?
Yes.
And did you sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Judge.
State, are you proceeding on the information as presented?
Yes, sir.
Next, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of fraudulent use or possession of identifying information less than 5 items as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We've discussed what's happened, Judge, and decided to go forward today.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Judge, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do believe that.
Miss Kelly, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, according to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's no application for deferred adjudication. State recommends community supervision. This will run concurrent with cause number 691768. State will take in consideration 2022 CR 6341B, GJ 768492. And Brenna, are you ready? Okay, thank you. I'm going to read it as exactly as it is, Brenna, without tripping over names, hopefully. Restitution is to be determined by the court through the Community Supervision Office. There's to be restitution to Anna Velasco, Draco Jackson, Lorena Grazgorowski, Arturo Saenz, Samuel Estrada, Cecilia Gonzalez, Maribel Gonzalez, Dejiman Woods, Nyla Rojas, Damian Reyes, and payable to victims under grand jury number 768492, SAPD number 220262228, Richmond Properties, 2022 CR 6341B, Metropolitan Construction. There's to be no contact with Walmart at 5555 De Zavala Road, Richmond Properties, Metropolitan Construction, Anna Velasco, Draco Jackson, Lorena Greskinkowski, Arturo Saenz, Samuel Estrada, Cecilia Gonzalez, Maribel Gonzalez. See, I don't think that J is pronounced. Dejiman Woods, Nyla Joe Rojas, and Damian Reyes. There's a comma after Reyes. Is there supposed to be someone else? Or is Reyes the last person? All right. Did you understand that to be the plea?
Yes, ma'am.
Defense? Is that the
Yes.
plea?
That's their agreement. And I wanted to request a PSI judge to get that restitution determined before the sentencing if
You want
possible.
to turn me back the trial court certification
Okay.
then? All right. And defense, Ms. Kelly, did you understand that to be the plea?
Yes.
Defense, is that the plea? Oh, state, that's the plea?
Yes.
All right. Show you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. They're asking that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 150 hours of community service restitution, CATS 1 and 2, and the MRT. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State?
State offer states exhibit 1 and
We reviewed it carefully and have no objection, Your Honor.
All right, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Brenda, we're off the record for a moment.
Oh, Judge, I folded a page at the very back of the steps to show you exactly what the allegation is that's charged.
Okay, no,
Top of that page.
all right, thank you. Can I see the paperwork on Marco Zavala? That was a plea. And thank you for doing that. I appreciate that.
I would have put a little sticker, but I didn't have one.
That's okay.
It's a long report.
Just one moment. Thank you. All right. That was my concern. I was like, surely I'm not imagining things. With regards to this waiver and consent to stipulation of testimony, there's a whole page that's missing.
Oh.
Oh, it's my signature page. It's not in there. So I don't know if something has happened. It should be the certificate for the defense counsel. And then my approval. I don't know where that page went. Oh, do you need a stapler remover? Brenda, I don't know why. Men don't ask for a stapler remover. There's a page missing. And I'm gonna need a PSI date for this case. And are we gonna need a TAP evaluation? Ms. Prepity?
I think that would be a good idea, Your Honor.
All right. Thank you. All right, we're back on the record. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication.
We only applied for probation.
Oh, you only applied for probation? Okay. Well, Brenda, it's just one of those days, isn't it? All right, the court is finding there's sufficient evidence to find you guilty. The court is finding you guilty. This will be set for PSI on February 6th at 9 a.m. The court will order a TAP evaluation and we'll need a full PSI with restitution. If you're drug tested today, what are the results going to be?
Negative.
All right. We can get you a drug test today, okay? All right, thank you. She'll need a drug test today. Do you need any water?
No.
Okay, all right, thank you. Here you go. All right, who's here on Sharona Williams? Yeah. We will. Sharona Williams, who's here for Sharona Williams? All right, thank you. Okay, all right, we'll take that up after this.
Your Honor, Ms. Williams, I don't know if she entered a plea on Monday. The plea agreement was for a misdemeanor deferred 2 years on deadly conduct. And then I approached on Monday to see if we could bring it back here and have that granted as opposed to waiting until January.
Okay,
We'd like to wait this.
so you'd like to go forward?
Yes, sir. That was our intention. It just didn't go that way.
All right, so she hasn't actually, she's done all the paperwork, but she hasn't actually been admonished or anything?
She's been admonished. She entered her plea and he just deferred.
You said it for a PSI.
He said it for a PSI.
Oh, this is another judge. Okay,
Yes, Your Honor.
thank you.
Judge Angela.
All right, thank you. All right, court is calling 2022 CR 3265 State of Texas versus Sharona Williams. Could I have parties announced for the record for the state?
Catherine Pollard?
Defense?
Eric Baker from Ms. Williams, Your Honor, is present.
All right, and are you Miss Williams?
Yes, ma'am.
All right, you entered a plea on December 5th of no contest and applied for deferred adjudication to the offense of deadly conduct. Are both parties ready to proceed with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Honor. No, Your Honor, other than my client has a completely clean record, always has, very responsible human being. I think this was the right result.
Right. Anything you wish to say? Ms. Williams?
No, Judge.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Judge.
All right. Do you have any children?
Yes, Judge.
What are their ages?
9, 7, 6, 4, 3, and 1.
All right, so usually I just do this for males, but I don't want to discriminate. So what are their dates of birth?
12/4/2013, 5/5/2015, 9/28/2016, 7/28/2019, and 11/14/2018. And the last one is 10/22/2021.
All right, so. Okay, she knows.
I would have failed that.
They say, well, they say,
they're
once
with me
you're
24/7.
giving birth, it's hard to forget the dates. So, are you employed?
Yes, I am.
What do you do?
I work for Alamo Colleges. I was working in childcare at the time
of the incident, but I can't continue working there or continue school with the charge.
Okay, so,
She can now, Judge, she will be able to after.
oh, she'll be able to go back after this?
Yes.
All right. So who helps you with your children?
I do everything. My mom helps me, my dad helps me, I have a sister as well, helps,
So you
and
plan,
grandma.
so are you planning on having more children?
Yeah, just this last one, that's it.
Oh, so you have another one that's on the way.
Yes, ma'am.
And when are you expecting that child?
April 29th.
Okay, and is your mom here?
Yes.
Does your mom want more grandbabies?
No.
Okay. So it's a, I can't imagine what that house is gonna be like on Christmas morning.
Full of joy.
Yes, I mean, always, but I mean, somebody has to clean up the wrapping paper.
They do it.
Yeah.
They have no problem.
Well, I will tell you the good thing about having a 1-year-old, 3-year-old, and 4-year-old. I think they're still at the ages where they enjoy the wrapping paper more than the actual gift.
Yes.
So you could probably just wrap some empty boxes for them. Or I should say, let Santa do it. You know, let children believe, you know, have their childhood dreams and memories. All right, let me see, just one moment. All right, so who is Mr. Ward to you?
That is one of my kids' dads.
All right, so what are we going to do with the? All right, state, I see you're asking for no harmful or injurious contact.
Yeah, Judge, we actually, about 6 months ago, came before you on that issue and you granted her no harmful or injurious as opposed to no contact. And so we just asked that to continue. It's been working so far.
Okay.
And just because they have to exchange.
All right. So this is what the court will do. 1 year deferred adjudication. There is a $1,500 fine probated. $100 hours of community service restitution. I'm going to order parenting classes. Once you complete parenting classes, that will satisfy your 100 hours of community service restitution. Proof of employment.
Judge?
Yes.
Question, if I'm in parenting classes already?
Yes, just give them the information that you've successfully completed that.
Okay.
Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. The aggression and hostility course. Gun safety course. With the gun safety course, is she going to be allowed to have, she's not going to be allowed to have weapons while she's on probation. So I don't know how she completes the gun safety course without a gun.
I've completed one before. I don't know if that'll apply.
Well, I mean, if you completed one before this incident, it didn't stick.
Judge, I don't believe you need a gun for the course. I don't think they use guns in the course.
Okay. All right, gun safety. Okay, she's saying it's self-defense. Do y'all want a jury trial?
No, Your Honor, it's there was maybe an arguable self-defense claim. It's complex.
All right, because if anybody wants a jury trial, we can have one next week.
But we actually discussed that.
Okay.
It was a very difficult decision, but I think this is the right call.
All right, gun safety course, regular reporting by Zoom or in person. Regular UAs. All right, probation, is there anything else that's needed?
Anything about field visits?
We can do one field visit. And we'll do one field visit, and if that field visit goes well, then probation can suspend field visits. If that field visit doesn't go well, then you can continue with the field visits. So whether probation is at your house every month, it's completely up to you. All right, is there anything else you need from the court in order to be successful?
No, Judge.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. All right, I think this is the wrong certification of appeal. Could you grab another certification? Thank you. They have different certification of appeals floating around everywhere, and I think this is the outdated one.
Okay.
Do you need the cause number?
Yes, Your
It's 2022 CR 3265.
The judge can approach.
Yes. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
All right, we can go off the record. Here's the thing, Ms. Williams. You have 1, 2, 3, 4, 5, 6, 7 children. And this case started off as an aggravated assault with a deadly weapon. And people say they want a jury trial and we're here to give people a jury trial. But when you have a jury trial and there are 12 strangers, and they will be strangers, it won't be your mom or people you know on the jury who say, I know her and this is what I know she would do. When you have 12 strangers deciding whether or not you're guilty or not, they may say it's not self-defense and find you guilty. And then guess what? The next thing they do if they decide you're guilty, they decide punishment. An aggravated assault with a deadly weapon, the range of punishment is 2 to 20 years. And if you were to go to a jury and they find you guilty and decide to give you 20 years, guess what? Your youngest child will end up being 20. And the only time your children will probably be seeing you is at the prison. And you'll be dependent on other people to take care of your children. And I do know that grandmothers love their grandchildren. They really do. But there's a difference between grandmother and mom. Like every child wants their mom. I'm sure they'll accept your grandmother as their mom because that's what she would end up being if you end up going to prison. You're going to have to start making better decisions for you and your children. And when stuff like this happens, guess what ends up happening? Child Protective Services gets involved. And I've done Child Protective Services cases. And you know what ended up happening with the number of children you have? They don't keep them all together. They end up, if available, they'll give some to your grandmother, some to their father's grandmother, some to an aunt. And then if you don't have those people, you know what ends up happening? They end up getting separated. And what I can tell you from my experience with Child Protective Services, everybody wants a brand new baby. So if something bad were to have happened with this incident and these children ended up in Child Protective Services, you know what would happen? People gonna take the 1-year-old, they'll take the baby, they may take the 3-year-old, the 9, 7, 6-year-old, they will scatter them somewhere else. And then the new baby, the 1 and 3-year-old will end up getting adopted. And there's no guarantee that they will be adopted together because that's what happened. And your children are depending on you to make appropriate choices so they don't have to deal with that. They want to keep their childhood. You understand? So you're going to have to start making better choices. Otherwise, there are going to be consequences that trickle down to your children that you may not want. You understand?
Yes, Judge.
All right. Good luck to you.
Your Honor, thank you so much for taking me.
You're welcome. All right. We're here on the immigration issue. Who's ready? All right. So I'm going to take up Schaefer, then I'll take up, is your client Tovar? All right. And you are Flores, correct?
Yes, Your Honor.
All right. Okay, so we're not on the record, so we have an interpreter. Everyone, thanks for your patience. It's been a long day. All right. So, counsel, did an immigration attorney have a chance to speak with him?
She did, Your Honor, and she promised to get me an immigration report as soon as possible.
And what time is she anticipating on having that?
Hopefully next week, Judge. You also sent me on another case on the 19th, if we could do this one on the same day.
All right. Ms.
Because
Fer-
the DA's office also needs to contact the complainant to see if they will do a no harmful or injurious. Rather than no contact.
All right, can we recall Mr. Antonio Flores back on the 19th? All right, Mr. Flores, do you have any questions?
Vamos a regresar el día 19 de diciembre.
No, I don't. Okay, all right, we'll see you back then. All right, thank you. All right, and then I have
Hablé yo con Cristina luego.
Tobar.
Okay.
Brenda, do you see what page Mr. Flores is on? I found it quick.
Gracias.
And you said the 19th, correct, Norma?
Yes, ma'am.
All right. So Hernandez Tovar.
Yes, Your Honor, this is the gentleman that's in ICE custody right now.
I'm sorry, what?
That's an ICE. So they reinstated the bond and then he got transferred to ICE and he's still in ICE. And I talked to his immigration attorney.
Who's the immigration attorney?
It's a private attorney. His name is Rudy Castillo. And he was denied the bond, the immigration bond, but they were going to try one more time, but I don't know.
All right, Ms. Ferguson on Tovar Hernandez, can you reset this in the new year? We'll see where we are at that point in time. All right, we're gonna come back on February 2nd on that one. And state, I'm being told that Tovar Hernandez is in the custody of ICE. If you all can check with the federal government on that.
Yes, Judge.
Or see what can be done with regards to this underlying case, because they don't allow us to do Zoom. All right, and then the next one is Mr. Benito Garcia.
Yes, Your Honor, and he's here.
All right, if he can come up on this one. Okay, Mr. Garcia, I show that the Padilla letter was completed. So where are we with regards to the case?
So with respect to that, Your Honor, Marcus and I were conferring about the possibility of, different type of charge. And we've explored that and I've been given a new, I guess it's a new offer. Right? Is that correct, Marcus?
Yes, Judge. Last time she provided me with the deal letter, we were trying to figure out what sort of plea we could work out that would be a bit good for all. I made a new offer to her today. I believe she attempted to reach Teresa Codobla, but was unable to. She said she'll continue.
I emailed her and I also called her. So it's a little bit short notice, so if the court wants to recall this case for next week, I should probably hear something back from Ms. Davina.
Can we recall this for a plea deadline date? Let's do it next week sometime. I don't know what the jail list situation is. All right, so we're gonna come back on December 14th. And could you let Ms. Davila know on December 14th? All right, is there anything else? All right, thank you. All right, thank you. Good seeing you. Thank you so much for coming down.
Okay. All right, thank you. All right, thank you.
All right, who's here on Robert Chevalier? And where's your client?
He's not here, it's set for Monday, Judge, the 17th. We're on a motion for continuance.
All right, I don't have the motion. All right, and is your client on bond?
Yes, Your Honor.
All right, State, have you seen this motion for continuance by defense counsel with regards to Mr. Chevalier? Do you have any objection? All right, Ms. Ferguson, on Robert Chevalier. Are we able to set this? When is your Mr. Fabian available? I'm sorry, Dr. Fabian.
Testify the latter part of January into February.
All right, so Norma, they're asking that this be rescheduled to January 1st. Can you put this for maybe the first week in February or second week in February? Yes. All right, we'll be back on February 13th.
Thank you, Your Honor.
You're welcome. And Norma, can you see if Mr. Cox is around? All right, who's here on Leroy Johnson? Good afternoon or evening, Mr. Porter. It seems like it's been a long, long day. All right, so I see these are first settings. What is happening with these cause numbers? What are we doing?
A couple of things, Judge. The charges before the court are not different indictments. So having said that, been in conference with the district attorney's office, they're going to reach out to the victim of the case, pending an offer. If it's offered, we think it's going to be, what we're requesting for the court is a short reset instead of something that goes.
All right, so it will either have to, when you say short, do you mean like next week or the following week?
Well, I think whatever is good for the court, because I believe what's going to happen, we're going to try to do this to the mercy of the court. She gets a hold of the complaints that she wants to, we could always call the court and have them ordered. Is that possible?
Yes. So what we'll do is I'll give you a January date. And if you want it sooner than January, just let us know. But I will tell you, December 19th, 20th. Well, I think December 20th. Well, really, it's the 19th. That's the drop dead date.
Okay.
Because I'm trying to give people a chance to spend time with their family for the Christmas holidays.
And also, it'll just give me a little time to look at these new indictments.
I don't want to be Scrooge before his heart got bigger. Okay. Or is it the Grinch? It's the Grinch whose heart got, yeah, I don't want to be Grinch or Scrooge. I want to be the people in the Whoville. You know. All right, Norma, what date in January? All right, so we'll be back on January 19th, but we may be sooner than that, Mr. Johnson, if your attorney wants it brought back sooner.
Yes, ma'am.
All right, thank you. But Brenda, I do think Scrooge, oh, Brenda's gone. Do think Scrooge is like the Grinch. That live action. All right, who is here on? Oh, this is done. Oh, you wanted to approach me on Miss Kelly? Yes.
Miss Clay just about positive and negative. She thought negative was bad and didn't want to say dirty, so she would probably be positive, not negative.
Ah,
So she can still do a test for a baseline if you want, but
Oh,
she
sure.
didn't want you to think that she was lying to you.
oh, no problem. Have her come forward.
Miss Kelly,
All right, so what are you going to be? Well, what have you been using?
Marijuana and meth.
Okay, so are you going to be positive for marijuana and meth today?
Yes, dirty for both of them.
Okay. All right, so what we'll do is when you come back for your sentencing, there should not be any meth in your system. You understand?
Yes, ma'am.
So between now and when you come back for your sentencing, you need to do some NA and AA meetings. I know the holidays are coming up and sometimes people end up using. And you never know what you're going to get. So I don't want you to be that person who ends up dying from a drug overdose. You understand?
Yes, ma'am.
So what I'm going to want you to do before you come back here for sentencing the next time, I want you to get into some NA or AA meetings. You understand?
Yes, ma'am.
And they're all throughout the city.
she's on GPS. I know they were offering them on Zoom. I don't know if they still are
All
offering.
right, just checking that and see if they are.
Okay.
Okay. All right, and then just talk to probation.
Yes, ma'am.
All right.
Thank you.
Thanks,
You're
Jen.
welcome. All right, who's here on, oh, Norma Felipe Ybarra? You say there's a vacation letter? Who's the attorney? All right, so where's his client?
Downstairs, Your Honor.
Oh, okay, well, we'll just recall this. When is he back from vacation? All right, let's put it after that. I think you're 19, maybe. Oh. Oh, well, there's nothing we can do about that. We'll have to put it in January. What date?
Yeah.
Yes.
I'm waiting for the UA on her to anymore.
No, she said she's gonna be positive. Yes. 26. Okay. All right, Norma, the people we have left. Oh, can I see the file on Isaiah Martinez, please? Norma, can we put Mr. Martinez in the new year? His attorney is in the hospital. Okay. All right, there we go. And where is Brian Kimbrough on Marlon Simeon?
On time.
Oh, did you do the line?
And Norma, what date did we give Granado Pena?
I'm here.
No.
Oh.
Mhm. He's on 7. All right. And then what date did we give Benito Garcia?
14th of December.
Okay.
I got it in my bag. Because I'm afraid if I drop it, I'd rather not drop it.
All right, so Norma, the outstanding cases I have, Marlon Simeon,
I told Abraham.
Sergio Salinas. Okay. Right. And then we have Mr. Cox on Matthew Salazar. All right, and Mr. Cox is here, so we'll take that up. And then do we complete Betty Jean Gonzalez?
Betty Jean never showed up. There has a doubt.
Right, could I see those files, please? And then Ricardo Alcorn.
That one, according to Todd Lesser, I guess the state is gonna reduce it or something, is that right?
Sorry?
Todd Lesser's case?
Yes, Your Honor, I just spoke with the big attorney, we're gonna review it down to misdemeanor.
Okay,
And I think that's what he's done.
What he said that she's gonna turn in the paperwork today, but we don't know how long it's gonna take for that to get processed.
okay. All right. Right, and that's done. You're welcome. All right. And then we, Deputy, can you look to see if Betty Jean Gonzalez is in the system?
Her case got recalled twice.
Okay,
Because the guy was in trial of that capital in the 186.
okay.
We told her to be here. I did give her a reset, so she was supposed to be here. But I don't know.
All right, so I'm gonna,
I don't know what you want to do, but I know she came in twice. She's one of the RICO defendants. She's the one that was with Linda Gonzalez and
okay.
Mr. Sheck.
All right, I know which one it is. All right, could I have a prosecutor, please? Court is calling 2000. Oh, Brenda's not there. I can write it down.
One second, Jeff. Let me make sure it's not there for tomorrow.
Okay. Oh, you know what? It is. Yeah, I have it as December 9th.
What was it?
It's Betty Jean Gonzalez.
Oh, yeah.
All right, so that's the night. All right, and then. So we have two more. Matthew Salazar. All right, thank you. And then we have Marlon Simeon. Okay, Marlon Simeon, he's in federal custody. So Norma, on this one, we're going to recall it and tell Mr. Kimbrough that he needs to be present in court. And this person is still in federal custody. So let's recall this one more time and recall it in January. All right, what date?
I can do that 23rd.
Okay.
No, they, Kelly printed it.
I don't know what turned it in. I said I'm gonna still talk and come up back in.
Yeah, I have a charging for you. I just wanted them.
Y'all are a bunch of fools. You see which way Kelly went? Did you see which way Kelly went? For that one?
Have no idea. He may be in the back.
Judge, you should know, it's your turn to base.
I try. Okay. All right, but it doesn't tell me who this is related to. It's just a blank paper. Okay, just 1 second. All right, I'll take that up in 1 second. Can we get the attorneys here? Yes. All right, can you mute us for a moment?
I have practice.
Not a.
Yeah.
No. This case.
All right, the court is calling 2022 CR 3264, State of Texas versus Matthew Salazar. Can I have parties announced for the record for the state? Defense?
Cornelius County.
And are you Mr. Salazar?
Yes, ma'am.
And probation, this is for regular probation?
Yes.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and that you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Salazar, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented? Mr. Salazar, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault of a pregnant person? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court doesn't have to follow it. If for any reason the court does not follow it and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. State recommends community supervision. They will take in consideration county court cause numbers 6988065, 670474, grand jury number 782139, 2022
Yes, ma'am.
defense,
Yes, ma'am.
state.
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
I know you.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours community service restitution, no contact with Amanda Bondoc, BONDOC, and the BIPP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence?
Yes, Judge, we offer what's the bar to state.
No objection.
Mr. Salazar, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of police reports and witnesses' statements, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, on the no contact with the plaintiff, the Salazar would hope that the court would consider no harmful or injurious contact, and because they have children together. And the complainant actually in the case judge didn't want to actually pursue it. And we're just hoping that the court will consider the no harmful contact. That of no contact.
All right. State, have you had contact with the complainant?
We have.
And does she want a no harmful or injurious contact?
She has not clarified on that specifically, whether she wants the no harmful or just no contact, but based off of these pieces, I believe she would want a no contact order. I can't say that for sure. It's an interesting situation.
And Mr. Cox, I want you to know, I recognize you as an officer of the court, and I do know you as I know the state. So what you're telling me, I do take it as truth, but I always like to know whether or not the state has had contact with the complainant and the complainant is aware of the plea and those type of things. So is she aware of this plea?
She's aware of the terms of the plea, the term being the 10 years probation.
But again, specifically, I'm not sure if they've discussed the no harmful or injurious contact.
Okay. Is there anything you wish to say, Mrs. Salazar?
No, man, I just said we have kids together and
All right. Kids are Billy goats, baby goats. Those
Yes,
are our
ma'am.
kids.
Yes,
You have
ma'am.
children.
I'm just trying to finish my college or so. So,
So here's my question. Are you employed?
yes, ma'am.
What do you do?
I'm working at mobile home installers right now, but I might go back to doing electrical work.
All right, I'm going to tell you, here's my issue with the no contact versus no harm for injuries contact. What I have before me is, from reading everything, you assaulted her while she was pregnant. So for me, that should be no contact. Now, if maybe once you've completed or started the BIP course and I speak to her, then maybe I'll reconsider. But for now, the answer is no. And when I read the police report, there appears to be some altercation, and then you went off with the child and then came back with the child. And that's a lot of confusion, chaos, and violence to be happening in front of young children. And how old was this child?
She was about 6 months.
So the oldest child was 6 months. So the child who was around when this happened was 6 months old. Is that what you're telling me?
Oh, no, she said she was pregnant, but she had already had a boy.
No. So she's saying she was pregnant. You're charged with assault on a pregnant person. You're saying that there are 2 children or
No,
just
no,
one?
no.
Just only one? All right.
I actually have an affidavit. Prosecution, I know that's not.
Yeah.
Seeing them, but it just.
Any objections to the
for the
court
court
reviewing that?
To know that, and if the court, I don't know if the court remembers, one time we had a hearing on this case, and this was a case where, the picture of somebody, a young lady trying to get into the window.
Yes.
That's.
Oh, no, I remember this case.
And Judge, just so you are aware, one of the cases being taken into consideration is about 2 weeks old, and it's another detail.
Yes. Well, here's the thing. We're going to start out with no contact. When people come before me and they want to have contact because they have children, it's like the time to think about that is before we get to this point. So show me something. Take some anger management classes, get your life in order, get your household in order. Then the court would consider, you being allowed to contact. Do you have family support?
Yes, ma'am.
Who do you have in your life supporting you?
My grandma, grandpa, my dad.
All right. And does she have family supporting her?
She all she had was me.
Well, no, I mean, people have more than just you. Does she have a mom, a dad, an aunt, a brother, a cousin, a sister?
No, her father committed suicide in front of her. So.
All right. So then this is what's going to end up happening. If there's, for you to see the child or something like that, you all have to make arrangements through a third party. You can't contact her.
So even if the victim communicated to the state that she wanted to have contact, would the court consider that? Not at this point.
Not at this point.
We need a little time.
Yes.
Water to blow under that.
Under the bridge.
Under the bridge.
Yes. All right. I appreciate that, Mr. Cox. Yeah, because I want to make sure that the issues and the confusion that brought us here don't occur again. And what I can tell you is when people say they love each other, problems are not solved with violence. When it gets to the point where people want to be violent with each other, maybe it's a relationship that people should walk away from. And if there's children involved, then you walk away and you say, you know what? I will always love you. We will always be friends because you're the mother of my child or you're the father of my child. But you and me, as far as a intimate or romantic relationship, not going to happen. And sometimes that's where we're at. I really wish there was a way that I could give people couples counseling, give people self-esteem counseling, give people financial counseling so they won't be dependent on somebody. It's best to go into a relationship having independent means and being able to support yourself without that other person, because then you can walk away. And I can only deal with you specifically, because I don't have more information about her or about your relationship or what goes on in your household. But what I'm telling you is you cannot have contact with her. If I find out you have contact with her, you're going to be looking at 10 years in the prison. You understand? If she comes over to your house, and as Mr. Cox showed the court before of her climbing through your window, you had better call the police and say, hey, I'm on probation. I'm under a no contact order, and this complainant is coming through my house through the window. And don't even do that thing where, oh, we're getting along fine. I'm going to let her come over, because guess what? It's the holidays. Tempers run high, and then the police get called. And what, you know, what's going to end up happening? Your attorney's going to want to come in and say, oh, she's climbing through a window. And I'm going to ask you, did you call the police? So don't do it. You understand?
Yes, ma'am. I have called the police on several occasions, though. I made several police reports that I do have.
All right. So, I mean, if she comes over, that's what you're going to have to do. So the court is going to, as previously stated, find you guilty, sentence you to 10 years in prison, suspended and probated for 10 years. There's a $1,500 fine that'll be probated. Take in consideration County Court Clause numbers 698-065, 670-474, grand jury number 782-139, 2022 CR 6538, the BIPP course, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with booster. Court is not requiring it, but if you do, then 40 of those hours will be waived. I'm going to ask for parenting classes with Triple T. If you, all right, well, we'll see.
I just recently completed it, ma'am.
From who? Shows, when did you complete
Got a
this?
certificate, like,
When?
maybe a month and a half ago while I was doing my college. I did it for CPS.
All right, so Child Protective Services is involved in this as well. Okay. Is Child Protective Services still involved?
We had court the other day. I think that's to be the end of it.
All right, CPS compliance, if applicable, just provide the parenting classes certificate to probation. So probation, if he has parenting classes certificate where he successfully completed it from CPS, then the court will accept that. We're going to do CPS compliance if applicable. There's to be no contact with Amanda Bondoc until further notice. The BIPP course, and Mr. Cox, you can check and see if they did the BIPP course as a part of CPS. I'm not sure. There's to be regular reporting by Zoom or in person. I'm going to want random field visits 2 times per month. And you can do those for 6 months to see how they are. And then if they're fine, you can slowly start tapering downward with the field visits. And the field visits, if you want to, can count as his appointment. Are there any drug issues with you?
No. I have heart problems.
I'm sorry, what?
I have heart problems and conditions. I don't.
Oh, okay. All right. We're not represented someone before who had heart problems, but I was still representing him for possession. All right. So
maybe allegedly.
yeah. Oh, no, I went to, well, I mean, there was a representation, but I did allegedly.
I mean, maybe.
Yeah. So, yeah. So it's to be regular UAs, proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Is there anything else that you need from me in order to be successful?
Not at the moment, ma'am.
All right, I'm going to show you what's entitled trial court certification. Oh, just one moment. Excuse me, shouldn't this be an affirmative finding of family violence?
Yes, Judge.
All right, there's an affirmative finding of family violence. All right, before I close the record or go to the trial court certification, I want to explain to you what an affirmative finding of family violence designation means. And then if you decide that you no longer want to do the plea based upon that, let me know and I'll allow you to withdraw your plea. So with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Oh, yes, ma'am.
And with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent. Do you understand? You want to talk to your attorney about that? Or do you understand?
Oh, that's fine.
All right, so knowing those things, do you still wish to go forward with this plea?
Yes, ma'am.
All right, so there's an affirmative finding of family violence. Is there anything else with regards to sentencing?
No, I think, Judge,
Okay,
the fees, probation fees, if there's a minimum, he's trying to get on his feet. So,
all right, and probation, the minimum advisory fees for Mr. Salazar, please. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So what are these names on your tattoos about?
My son, Matthew II, my daughter Annabelle, well, my wife, which is, Amanda. And then I just have blessed right here. I just have my kids' names, and then I have my other daughter's name right here, Zoe.
So how many children do you have?
Oh, I have 4.
What are their ages?
Well, I got a 14-year-old, which I haven't seen in a while, and then I got a 10-year-old and an 8-year-old, and then I got a 2-year-old.
What are their dates of birth?
My oldest, hers, is February 24th, 2000. No, February 24th, 2014.
Okay.
And then it's 1/16/12, 5/12/14, and then 10/29/2000.
All right, so here's the thing. You have a felony conviction. It's not the end of the world because for you, because one, you're not going to prison, right?
Yes, ma'am.
You're going to have to start making better choices or you may end up in prison.
Yes, ma'am.
Hopefully you want to be the type of father that your children look up to you.
Yes, I want to be there for my kids. Like I don't want them to grow up the way I did. Without a father.
That means you're going to have to change your ways. You understand?
Yes, ma'am.
All right, I'm giving you a chance on probation. The key to being successful in probation in this court is being open, honest, and communicating.
Yes,
You
ma'am.
understand?
Yes, ma'am.
All right, good luck to you.
Thank you very much, ma'am. I appreciate it.
All right, you're welcome. Yes. You're welcome. Yes, once he turns that in to you, he can get credit for it. Yes.
Thank you.
You're welcome. All right, Brenda, we're going to stop